to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
So we'll do roll call.
Noah Judd. Here. Ken Hayes.
Here.
Ron Bell.
Here.
Sue Ford. Here. Ted Miller.
Present.
Norma Turner. Here. Maggie Roth.
Here.
Steve Burke.
Here.
Courthouse. Glenn Wiggins.
Here.
Connie Beauvais.
Present.
Barbara Christensen. Rod Fleck.
Here.
Mike Doherty. Here. Don Forsythe.
So Barb and, of course, they both said, let us know they wouldn't be here. I don't know. Okay, you have in front of you the agenda, so I'm either looking for modifications to the agenda or approval as is.
I'd like to add to the agenda reorganization of subcommittees just prior to the subcommittee report.
Okay?
I second.
We actually won't need a motion on that. Okay, anybody else? Mike?
Well, you already your memo of about 2 weeks ago, you mentioned on the 6th, to submit other materials. I have one page item that relates back to something I talked about, generally all agreed back to the second or third meeting in January. Just some open government type issues. So I can hand that out.
Yeah, as you noticed, you've been getting papers from people who are handing these out. What it was is that Trish had some obligations in her life that she needed to get the agenda out by Monday or Tuesday of this last week, so we just asked that people get them in, but we realized that the time is pretty short, so if you want to wait till this meeting, you should. Okay, any other concerns about the agenda? Hearing none, someone want to move to adopt the modified agenda? So Rod, you moved, who seconded?
Rod.
Maggie, huh? Rod and Maggie. Okay, those in favor?
Aye.
And opposed? Thank you. Correspondence, Trish?
I had approval of minutes prior to correspondence.
You're right. Thanks for keeping me in line. So we have 2 minutes. Remember last time we met, there was a question about how something in the March 11. You'll notice that we postponed adoption of the March 11 minutes, and they have been modified slightly to add a little more substance to Jim Jones's presentation in addition to his handout. So, did everybody get them this afternoon? Okay.
No, I didn't.
Okay. You want to look at them, Connie? We have a copy down there.
Oh, did those come from before?
They came out this afternoon because Trish was spent Easter weekend putting them together, so they finally came out this afternoon. Do you want to look at them before we approve it?
Okay.
All right, okay. Any comments on March 11 minutes?
I did not receive them,
Okay.
so I will abstain.
Okay.
I received them, but I just have time to read them. Yeah, same here. Also.
Well, I would say then let's take 3 minutes, and all of you who want to read them, want you do that so we don't want these minutes to pile up. And then we get you a copy. Nola, you need one?
Yes.
Because if we have too many abstentions, we're not going to pass them, so let's just read them for 2 minutes from them. Whatever it takes. And everybody? I'm sort of a quiet eye. So, okay, will you just raise your hand if you approve the March 11 minutes? Thank you very much.
I'm going to abstain because I wasn't at there.
Okay, so Ken abstains from the vote since he did not attend.
I abstain for the same reason.
All right, and Nola also. So now we have the March 16th minutes in front of you, so let's take another couple minutes. Right. Okay. No, we're just reading the minutes. The attachments are for your perusal at another time. Thank you. Since we have a 3-hour limit on our meeting. Okay, no move that we consider the March 16 minutes
No,
at
it's
the
very-
next regular meeting. And who seconded it?
Steve, first.
Steve.
Yeah, no, I heard it wrong.
Those in
That's okay.
favor?
Aye.
Oh, excuse me, before we vote, are you voting, Glenn, or do you have a question?
No, that's it.
All right, thank you.
Excuse me, Norm, I was with Connie and I just.
Okay, well, we,
In a second.
Nola moved and Steve seconded that we consider the March 16th minutes at the next regular meeting because there's some confusion about what additions were. Okay? All right, so we'll have those on our agenda next time. Thank you. Okay, so now we're ready, Trish, for you with correspondence.
You have 3 that you received from a Susan Schottenberg. One, let's see here, voter's pamphlet. Another to prohibit local legislative authorities from using county collected taxes to promote bonds and levies. And a third to prohibit all local government surveillance of people and private property without a search warrant. Kai Alberg submitted some changes to section 1 of the charter. And I gave you a memo from Jim Jones of the information packet about setting salaries for non-judicial elected officials in Clallam counties. I forwarded one from Stephanie Noblin to ask if it was possible to place ballot items on more than one election cycle. I believe I responded to her. And then I have Ted Miller submitted a Charter Review Committee 8 subcommittee report that came in on Thursday. And it was made, and Glenn submitted some changes today. Mark Nichols asked me to forward a link that speaks to the doctrine of incompatible offices. Also.
Okay, thank you. Okay, now we're at the public comment period. The sign-up sheet is on the podium, and remember that it is a 3-minute time limit, so thank you very much. Anybody? I don't have the sheet, so if you've signed up, please step up to the podium.
I'll try.
Thank you. Get your exercise today.
Yeah.
Okay, the first on the sign-up sheet is Kai Albert.
I'd like to speak essentially on what I submitted over the website, but I have some additional information. I'd also like to give you the opportunity to ask me any questions if you have any. What I am proposing, but I'm Kai Albert, 4513 Mount Pleasant Road, Port Angeles. What I'm proposing is some amendments that relate to strengthening local control, specifically over our land use regulations and policies. To further that, I would like to suggest that in line 4 of section 1.20, we replace the word cooperation with the word coordination. As I'll explain in a moment, this has a very significant legal distinction between those two words. Secondly, I'd like to suggest we add to that section, or we add a new section 1.25, that would be something as follows. The county will require all federal and state agencies to obey all applicable laws, including managing all federal and state public lands in accordance with law. Whenever a federal or state agency shall attempt to implement policies, plans, or rules that conflict with local ordinances or rules, the county shall assert its coordination authority and engage in coordination with such agency, unless the county prosecuting attorney provides a written legal opinion stating that coordination is not available in that specific instance. The county commissioners and the director of the Department of Community Development have an affirmative duty to protect the county's human environment and shall place the county's human environment on an equal footing with its natural environment. The county commissioners shall make state and federal authorities show cause before they pass regulations detrimental to the county's human environment. And lastly, I'd like to add to my proposal that I made here on February 17th, which had to do with a cost-benefit analysis for environmental regulations that decrease property values or that have a gross aggregate cost exceeding $5 million. An addendum to that that also requires a peer-reviewed scientific analysis to the extent any such rules purport to be based on science. The short remainder of my 3 minutes, I'd like to briefly tell you about coordination. It's a legal concept. It is enshrined both in federal and state law. The handout I gave you is regarding federal law. Washington State is one of the states that also has the concept in state law. It's the Administrative Procedures Act. It's in the RCWs that govern the way the Department of Ecology is supposed to comport itself. If followed properly, it puts a local government on the same level as a state or federal agency versus cooperating status, which is an inferior status where the agency can dictate to the local government. And I think that is something that could have stood us in good stead with issues like the recent water resource rule in Area 18 and Dungeness Valley. I think we would have done better protecting local interests if we had been able to negotiate with ecology on an equal basis. This would set the stage to be able to do that in the future. Thank you very much for your attention.
Well, actually, public comment, we just have public comment. In public hearing, we have an interchange.
Okay.
Thank you.
Does that prevent us from asking questions, though?
As long as you stay within the total 3 minutes.
If he has a question, I think you should ask him.
I was just curious if the coordination's been tested everywhere and legally tested so that we know that it would work.
It has been utilized in a number of western states. It's been utilized in Idaho in some counties. It's been utilized in Northern California in some counties. It's been utilized quite successfully, mostly in coordinating with federal agencies, but there's no legal reason whatsoever that you cannot use it with state agencies. It's a somewhat lengthy process. I don't know that in Washington State it has been tested through all the way to the end against a state agency yet.
Thank you. Did you have a question?
Well, yeah, that was the sense of my question. Has the Washington State Supreme Court ruled on it to your knowledge?
Well, the Supreme Court does not really need to rule on this PRCW, so I mean, there's no reason to believe that it would not be upheld. I do not believe there has been a lawsuit that made its case way to the Supreme Court. Almost always in the other states where this has been implemented, it has not led to a lawsuit. Once the federal agency was educated on the concept of coordination, they then worked on an equal level basis negotiating with the local authorities and the issue stayed out of court.
Thank you. Okay, Dick Kelly?
I'm Dick Cohen, 72 Mount Pleasant Heights Lane, Port Angeles. Tonight I represent myself and also the 80 members of the Port Angeles Business Association on whose behalf I speak. I speak in favor of a new section to be added to the charter that could be paraphrased as follows. Any proposed ordinance set forth by the county commissioners that would incur an additional tax upon the citizens of the county, resulting in an expected annual revenue exceeding $500,000, shall be decided through the election process by a majority of those voting in the last general election. We want this concept enshrined in the charter because politicians like to spend money. Lots of it, because it's easy to spend other people's money, because if you don't work for it, if you don't sweat for it, if it isn't your hard-earned cash, it's easy come, easy go. Citizens of this county are the ones that work for the money, and it should be up to them to determine how much they wish to spend and on what. So if our elected politicians can make a good enough case for their spending, the voters will approve it. And if they can't, the voters will let them know. Thank you.
So you have that in writing, Dick, for Trish? Thank you. Okay. Next is Harry Bell.
And so I'm Harry Bell, 1216 East 2nd Street, Port Angeles. I also am here representing the Port Angeles Business Association. I have passed around a letter that our association has unanimously voted to deliver. One section of that letter you just heard from Dick Pilling. Some folks after me may enhance some of what I have to say. I'm just going to read this letter to you for the sections you haven't heard yet. Please consider the following proposals that were unanimously adopted at our last PAPA membership meeting. New section, proposed land use ordinances and policies or changes thereto, costing the citizenry of Clallam County in excess of $5 million. Must be approved by the majority number of those voting in a general election. That's general election. New section, if the county enforces a land use regulation, for example, Shoreline's master program, critical areas ordinance, in-street flow, comprehensive plan, that restricts the use of private property or any interest therein, and has the effect of reducing the fair market value of the property, the owner of the property shall be paid just compensation. A little bit more of that section. We also support strongly the Director of Community Development remaining in elected position. And not in this letter, but will be delivered to you later, is our support to reconvey county trust lands back to the county for management by the county. Thank you.
And Lois Pastor-Perry.
I'm Lois Krasky-Perry, 215 Stellar Ridge and Swim. Trish, I will be turning this into you and sending you an email tonight. Great. I would like to address to the charter, and thank you for all that you're doing. I served several years ago, and I think Rob is the only one that I did serve with. I know it's a lot of work, and I appreciate everything that you're doing. Okay. I served as an elected Home Rule Charter Commissioner for District 1 in 2002. We spent much time on discussions and listening to testimony about the pros and cons of the Director of Community Development, by appointment or election. There were many problems at that time with the decisions being made by that director. We decided to place on the ballot recommending an elected Director of DCD. That November, the voters had spoken, and with over 60% voting yes, we were able to place it on the ballot. 5 years later, it was determined by another elected charter commission to place it on the ballot again, and the voters again voted by a large percent and said yes. In a Seattle Times article in November 2003, the chair of our commission, David Cummins, said, quote, "We cannot look elsewhere for how this can work," end of quote, as he answered their report on Clallam County having the first in the nation elected DCD. I can say now that we have 12 years to see it can work. The voters have made very informed decisions based on the biographies and list of credentials of those running for that office. Elected Rob Robertson, John Miller, and Sheila Rourke Miller have done a good job over the years. Mary Ellen Wingborn apparently is working hard as well. The decisions to make the DCD an elected position was a wise choice. I believe we need to keep this in place and do not waste a spot on the ballot when there are other important issues to consider. There are usually only 5 items or less placed on the ballot by the charter. Voting by districts, I would like to recommend voting for our county commissioners by district. People who live in their jurisdiction know them and can make well-informed, wise decisions when considering them for that office. A charter every 4 years. 8 years for another charter commission is too long to revisit it. It is easier to recall issues in 4 years than waiting for 8 years to pass. This would also place it on the presidential election ballot. Please consider my recommendations for placement on the ballot so the voters can decide. Thank you.
And next we have Carol Johnson.
Hi, I'm Carol Johnson, Executive Director of the North Olympic Timber Action Committee, and I'm here to speak on a topic that one of your subcommittees has already discussed, and it has also been mentioned here this evening. The North Olympic Timber Action Committee recommends that the management of Clallam County Forest Board Trust lands be taken over by the county. The public should have the option of voting on whether Clallam County can have their forest trust lands reconveyed to the county, where these lands would be managed in trust to produce revenue. This would reduce the overall management costs and leave the county in control of the timber harvest. Grace Harbor County currently manages their timberlands for their benefit outside of the management of the DNR. Thank you.
Next is Susan Chatterford.
Susan Chatterford, 214 Alderview Drive, Port Angeles, Washington. I have 2 more proposals tonight. First is a proposal to make union membership optional for county employees. Public employees should have the right to work without being forced to join a union. Only 35% of public employees belong to unions, so when given a choice, a large majority of employees prefer not to belong to public unions. Mandatory union membership unfairly discriminates against job seekers needing to provide for themselves and their families, but not wanting union membership. Under forced membership, public union employees hold a monopoly, preventing competition. Therefore, public funds may not hire the most competent, but only those joining unions. And I think this proposal could be applicable to Article 9, dealing with employee contracts, or 10, dealing with non-discrimination. My second one is for transparent contract negotiations between county officials and union employees. When Commissioners McIntyre and Peach spoke at the recent commission meeting, they discussed the need for transparency. Clark County commissioners have proposed transparent negotiations in their county. With transparent contract negotiations, representatives on both sides are held accountable. Union representatives to their members and elected officials to the taxpayers. This proposal does not ask that citizens have a voice during negotiation, but only the ability to monitor the discussion and agreements. In 13 states, the public has partial or complete access to union contract negotiations. Washington voters passed an Open Public Meetings Act by initiative. It reads in part, "The people of this state do not yield their sovereignty to the agencies which serve them. The people, in delegating authority, do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments they have created." That's RCW 42.30.010. I believe this amendment would be applicable to Article 9, dealing with employee contracts, or Article 10, relating to county personnel matters, employees, and contracts.
Thank you. Is there anybody else who didn't sign up but would like to speak? Okay, Ed? And when, for the record, Ed, if you give your address and introduce yourself, please.
Good evening, Commissioners. Ed Bowen, PO Box 111, Clallam Bay. I come before you on 2 items tonight. One is a campfire item. I thought I was going to bring to you a new proposal, but it looks like your subcommittees have kind of hit this. I want to propose the group tonight. You consider either a new section in here that I'm going to title from the campfire that I had, my neighbors, called the Citizens Ethics and Oversight Commission for Clallam County Government Public Servants, including elected officials. Now, you'll notice I put in there public servants and not just elected officials. It appears that within your subcommittee work you had something similar called Charter Enforcement Commission. I think I'm kind of on the same wavelength, and my neighbors are on the same wavelength, but I think the difference is, from my perspective, I'm looking at all public servants to be held accountable to some form of an ethics commission. That's why I say Ethics and Oversight Commission. I think this This really wasn't a highlight for me for your review, but it became apparent that with all the little issues going on with county and staff, it seems like this would solve a lot of the problems without changing whether DCD is elected or all these other things, or whether the administrator is this or that. So that's my proposal. And then lastly, looking at your subcommittee also, you addressed from the sheriff in dealing with credentials for the office of sheriff. I'm going to have to go on the record tonight that I'm kind of offended by this, because I remember when the sheriff briefed you on this, he talked about some nut could get in office. Well, some nut could get in office because the voters voted him in. And so that's the number one criteria. The voters get to choose who they want to be sheriff. And limits the voters to what they can and can't do. And so I'm not totally against credentials, but this is kind of a rough area for me. And I think we need to leave something that deals with the vote. We need to leave it to the wisdom and judgment of the voters and not set some kind of credentials. Thank you.
Thank you. Anyone else who didn't sign up but would like to speak? Hearing none, we'll close the public comment period and move there's a financial report which will be postponed until next meeting because Barb Christensen is out of town for this meeting. But as part of that financial report is when you submit your mileage. Trish has asked me, have you looked at Connie's report here from Article 8? And she said, would you please use it as a role model, that after you've had a subcommittee meeting, if someone would write up what article you met on, who was there, and where you met, and when, that kind of information is needed if you just submit mileage, and it says I went to Bella Rosa, if there's nothing no documentation showing that there was a meeting at Bella Rosa, then they can't pay the mileage. So if you're looking at your subcommittee reports, this is all part of modifying our process, if at the end of each subcommittee, someone would just write up a paragraph with that simple information, where, when, who, and what, and then submit it to Trish, and then when you submit your mileage, you'll get reimbursed for it, because there's a record that a meeting actually happened at that time in that place. Is that okay? Yes, sir.
So individually, we don't have to put that down, just somebody from that committee.
And we just need to have on the record. So yes, we'll say there 5 people met on article whatever, if one person is designated right up that these 5 people met at Bella Rosa on Wednesday, March, blah, 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 the 26th and whatever. And that is submitted to Trish, then that's the paper record. So all 5 of the people that attended that, when you submit your mileage, there's a paper record showing there was a meeting at that time in that place.
For those of us that have already submitted our mileage, do we have to resubmit that after somebody does that communication?
I don't know that question. Trish, do they need to resubmit, or do they just need to get the...
I have that committee one report, but it didn't have a date or a time or any of that. So if someone can provide that information and that corresponds with the mileage that you submitted, that would be really helpful.
So all the meetings that were held, you go back and make sure that somebody sends a record about that meeting, who, what, where, when, then the mileage you submitted will be documented.
So we could just add that tonight, and if we've given our reports, we can just add that. Okay.
Glenn?
Trish, did you get one for Article 12 from me?
I did, but I think I got it after the agenda went out.
Oh, okay. Can we?
Which I believe I acknowledged in correspondence.
We had copies made today, Trish, to get around. You want me to send you?
Okay, Frank.
Okay. Is that clear? That if we just have a paper record, who, what, where, when, for each subcommittee that has met, and Trish has that in the record, then your mileage will be honored. Yes, Nolan?
If I look through some of these reports, some of them have part of the information, but not all of what you're asking that action?
Well, that, we are gonna have a discussion about subcommittees. That Sue asked that to be on the agenda, so that can be part of the discussion. Ken?
Well, just a clarification, technically, these aren't subcommittees, these are committees. We don't have a committee that we're a subcommittee of, because we're committees. These should be called committees.
All right. I got in trouble because I called them task force, so call them whatever you wish. Just put down what you did, who you were, and why you were together, and where, and we'll be happy with it, so. Okay, did that answer everyone's concerns? Okay. So, wait till Rod gets back in with his print, and then the next item is going to be, I got my glasses on. Sue wants to have a discussion on reorganization of committees.
You want me to wait till Rod gets back?
I would like that. Plus, I don't remember many.
Oh, okay.
Okay, is Rod?
Rod is getting ones.
Oh, okay. Well, yeah, I know. Attrition. We probably will need to, in this discussion, start to set up some timelines as to when things can be, need to be submitted or to be in the packet. I was telling Trish today that if this charter review process is feeling more random, abstract, or something than it has in the past, and I finally made the diagnosis that's because this is the first charter I've been on that we had such a use of emails. Before, we just had simple testimony and letters. And emails just sort of make things a little bit crazy sometimes, even though it is a great way to share information. So, okay, so I think we're all back in the same room at the same time. So Rod, we're on to the next agenda item, which is going to be, Sue wants to talk about reorganization of committees.
I'm just trying to hand out.
Thank you, sir.
We think this is the one, but
All right, yeah.
okay, well, I'm not running back there.
No, okay.
We're gonna wait a minute.
Yeah, let's do the item on the agenda and move to
This one.
Oh, let's,
Nothing going to be difficult.
okay. I think we'll move on the agenda items first.
Thank you.
Okay? All right, thank you. So Sue, you're on.
Thank you. On March 26th, we held 3 subcommittee meetings, Articles 1, 2, and 11. It just so happened that the same members, most of the same members, were on all 3 of those committees overall. We had Article 1 and Article 2 met, and then Article 11 was supposed to be subcommittee let's see, B. Yeah, subcommittee B. I'm sorry, that's 6, 11. Yeah, subcommittee B. We had a subcommittee A and a subcommittee B. 3 of the members that were on subcommittee A happened to be at the meeting for subcommittee 1, for Article 1 and Article 2. And so we were short on people. We did not have 7 people present. And so those members stayed for the meeting with Article 11. And I also stayed. So because subcommittee A has not yet met, I would like to move that for the benefit of ease of meeting for the commission members, that we change up Article 11 and put myself, Nola Judd, Ted Miller, and Maggie Roth onto subcommittee B. And I've talked to Celinda Barkas, who was currently on subcommittee B, change her to subcommittee A. And she has agreed to do that. So that's my motion, my initial motion, and then I've got another one to make following that one.
What are you doing with Norma?
Well, that would be a committee of 3, Norma,
What about me? I'm
Ken,
supposed to be-
and, yeah, Norma, Ken, and Celinda.
But originally, we were organizing them by where we live to make it more convenient.
Yes, but it happens to be more convenient for those of us because of the way we're doing the back-to-back meetings for those committee members to be at that committees. Rather than jumping around and having a lot of different nights of meetings, we can do it all in one evening, which helps with those of us who work for a living.
Do you need the motion on the floor before we do the discussion, or?
We can have a general discussion. If you want a second motion, we can discuss the motion.
My motion is to move those 3 plus myself to Subcommittee B and move Celinda to Subcommittee A.
So I can second that motion for discussion. Nola, Judd?
So the motion is now on the floor for discussion.
Is this Article 11 only?
I guess.
Yes. At this point.
I will
I
take
have one to follow it.
I will take the prerogative of the chair and address the motion. I have a problem with this because if you remember, we adopted a calendar and had a mistake in it. We all knew it was a mistake, and I tried to change it, and I was told because it was a commission decision, we had to bring that back, and we had to look at that calendar and have a new motion to approve the language change. So I was under the impression that when the commission as a whole set these committees up, they were set up because you all asked that they be allocated by districts, so that's what we did. And for me, it made sense, I don't know about the rest of you, that we try to make committees kind of balanced, and that they have as robust a membership as possible, because remember the rule that a minority report has to be more than 1 person. So if you get a committee of 3, you're not going to allow for minority reports out of committees of 3. So the other problem, and the other thing that this was set up is we all knew who was supposed to be on our subcommittee, whoever they were, and then we left it a little bit fast and loose as to how those committees met. So personally, being the aggrieved party, I was never notified that Section 11 was meeting. I simply got an email saying, we all met, and you need to form a new committee. I have a process problem with that. That I have no problem with redoing the committee structure in a way that's convenient. But it is my belief that that restructuring should come to the entire commission to be restructured before a whole bunch of people just decide because they're in the same place they're going to meet and they don't have to notify everybody else. I don't know if Ken was notified, but I wasn't notified.
I have a real problem with it. I mean, it seems the fact that you guys decided to reorganize a committee and just meet, I find completely offensive, quite honestly, Stu. I mean, it seems a gross violation of everything we've been getting hammered on public process and transparency. I mean, I'm appalled, frankly. How do you just suddenly decide to change the structure of things? I mean,
For clarification, which subcommittee met? A or B?
B.
Okay.
No official subcommittee met. They just decided to have one.
No, that's not true.
B met. B met.
B was set to me.
B met and included 3 members of A, which was the majority of A.
So you're not being notified.
No, I wasn't notified.
But you're on A, not B. Which
So
makes sense.
If you look at subcommittee A, there are 5 people. 3 of those people then met with the subcommittee B group, and 2 of us were never notified that that was going to happen. And then we were told we all met. I just have a problem with that.
Well,
Luckily, I don't know what you decided. And, you know, Article 11 is not the beginning, the end of the universe. So it's not like it's a big, significant issue, except frankly, I like to be on committees because I like the philosophical discussion about what's going on. But, I mean, why do we set up committees if people can just meet for coffee and decide there's enough people there for meeting, let's go for it? It feels fast and loose to me, so I have a problem. So I'm going to know that you're
I was at those meetings that night, and My feeling was that no one had stepped up to the plate on subcommittee A. We were already halfway past the time that I thought we needed to have input for this meeting. It seemed very logical to me, since we are all on the same topic and they didn't have a full quorum, for us to move into that, so there was a group of people that could make a definitive discussion. I think that your concern was that you were not called, but the problem is the meetings went 4, 5, 6, and 7. There would have been no time for you to have gotten there, even if we had notified you. I'm sorry.
I live 5 minutes from Villarosa.
The point, one of the points that I believe Steve made was that you are not on Subcommittee B, so there would have been no reason to contact you regarding that. Subcommittee B was already meeting.
Like I say, I just have a problem with process, and I think, for me, Connie, I'll get you just a second, that if this committee, if this commission is gonna set things up, we probably won't set it up perfectly. There'll probably be some glitches. So let's all come back, figure out what the glitches are, and then set some new rules that we all buy into. But I think the key part for me is that whatever we do, we make it equal access so everybody gets notified. So there's some discussion on that. So Connie.
That particular night, it was never intentional to leave anybody out. When we sat here that previous commission meeting, and we were busy running around in groups trying to set up all the meetings, we had set up a meeting for March 26th at 4 p.m., Article 1, 5 o'clock, Article 2, 6 o'clock, Article 11. But then we had one commission person who wanted to switch 1 and 2, and I don't think everybody got that note. Meanwhile, we had some people who were there for Article 2 during Article 1's time, and some people didn't show up, so that's how that happened. Article 11, and Sue was there for you were there for Article 1, and that was the one at 5, and so she stayed for the one at 6 because there weren't that many people there. There were a lot of people for Article 11 that didn't show up. So it wasn't a majority or anything. So she stayed for the discussion. So I'm sorry there's hurt feelings. But it was...
It's not hurt feelings, it's process. I'm very much a process person. And I realize that I'm not impugning intent. I know people wanted to get things done. They wanted to meet. They wanted to have discussion. But I think, we're going to be making some really hard decisions. And I want to be able to trust that once our commission makes a decision, it is a decision that holds until we come back and decide to change it as a group, not as some subgroup. So it's a process question for me. So Steve, and then we'll wrap this up. We have a vote.
I think it was designed to be very loose as it's been designed. I agree that it's a little bit too loose, and I think we could do some stuff to firm it up, like assign somebody to each article that is either the clerk or the note taker or someone who is the point person for that article, so we don't have these difficult problems about not knowing who's been contacted, who can come, because with the email, you don't necessarily track who answered even. So you don't know if they even got the email. And if you had a point person for each one, and so I can't fault anybody for being loose when it was designed loose. And so I think we can firm it up though.
I don't think it was designed loose, it was just let loose. That was part of the problem.
Well, whatever you let, that's what you designed.
I don't recall anybody other than Group B putting the time frame up for Article 11.
Well, it's all of these committees, the ones that I've been calling somebody and the committee just decides it's time to meet and they send out an email. I mean, I'm on 6 and no one's called 6A, and so I sent out an email saying we're going to meet this week. And I think Steve's suggestion is probably one that may help solve that. If people would raise their hand.
Did you get a notice on 11A?
There has been no notice on 11A.
I know, because I was given a notice that 11A didn't exist anymore. So anyway, that's, so it's the process. I think we need to figure out what the process is that everybody's going to be notified. And Steve has a suggestion, maybe you have a person on each subcommittee that's responsible for calling meetings. So whatever, as I say, it was a new shot. You guys worked hard, you had lots of meetings. I commend all of you for the amount of time and energy you put into this.
So are we doing an 11A and B, or?
That's what the motion is.
That was my
Well, it's
statement. I
split.
thought that this motion was trying to correct that concern and get labeled what actually did happen to be able to continue. And I think Steve's point is still valid. Those, all of them, I think, need a spokesperson. But that's aside from.
Anybody who hasn't made a comment? Ron?
I think the process as agreed to should have been adhered to.
Yes, I agree with that too. In an open public meeting, we discussed a lot of things. And apparently, after the meeting, I left as soon as the meeting was over. Somebody arranged a lot of these subcommittee meetings, probably with good intent, but not everybody participated. And then apparently, they weren't noticed very well.
We were all invited at the closing of the last meeting, and nobody stayed except 6 or 8 people.
Yeah, it was very clear that we were supposed to get together at the end of the meeting in the groups and come up with some times.
Yes, our chair called for that.
I vaguely remember that part.
Quite a few people did, because I got like 4 appointments.
It still wasn't a public meeting, probably doesn't have to be, since it's a small minority, that there were, say, 8 of participating and scheduling some, that's the majority of the commission.
Oh, it definitely was a problem, because some people like Ken, you left right away, and so you didn't get into the circle of knowing who was meeting when. And
So
that is a problem.
I wanted, so see, I just want to throw a comment in. What you asked to have on the agenda was a discussion to modify committee process. So, but the motion that we're entertaining is a very specific.
I did not use the word process. You didn't? Nope, I did not. Well, you may have put it down, but that's not what I said.
So you asked for reconfigure, reorganizing committees.
Right.
Okay, so Sue?
I would like to point out that when we set our guidelines, that's all they were guidelines, proposed subcommittee guidelines. And during the discussion that we had, we were going to try this and see how it worked. And it was supposed to be, in my opinion, this is how I got it anyway, it's supposed to be loose enough that we could, change things around if we needed to make it work. And so this particular situation makes it work when we have back-to-back meetings with 1, 2, and 11. Rather than having the same people that are on 1 and 2 have to go to a different meeting on a different night when we're working. It makes it difficult. And so, to me, it's very logical to just change up this particular committee to move 3 people from Committee A to Committee B, and move 1 person from Committee B to Committee A. Simple as that.
And you're staying on the committee?
Yes, I am staying.
Even though you weren't originally on it?
Yes.
And I also was planning on staying on the committee. It's just very convenient.
Well, so I don't know if you're ready to vote on this particular motion. My difficulty with the motion is that it is so specific that I think what I'm hearing in the discussion is we really have a bigger issue, and that is notification. So, we can vote on the motion, but I think the real discussion is if I'm hoping that the committees, subcommittees, whatever you want to call them, will move forward and continue to work. It sounds like we just need a more defined process to make sure everybody gets notified of whatever article they signed up said they're interested in. So that's another discussion. So any other comments, or are you ready for the motion? The motion is to reconfigure Committee A under Article 11. So basically it would move Nola, Ted, and Maggie into Committee B and move Celinda up to A. So it'd be 3 versus 7. Hardly balanced.
Are the names that you mentioned okay with that?
They are the 7 that are already met.
So they're all okay with the move, including Celinda?
Yes.
Okay.
But it does create a 7 versus 3, which is sort of an imbalance, but that's up to you to decide if that sounds rational. So, any other comments? If not, we'll call for vote. Those in favor of the motion? Raise your hand, please. 1, 2, 3, 4, 5, 6, 7. No, did I get? I don't think I got all the hands. 1, 2, 3, 4, 5, 6, 7, 8. And those opposed? Oops. 1, 2, 3, 4. Okay, so the motion passes. Okay. Now, I think that the real discussion here is how do you make sure people actually get notified when they have an interest to be on an article? So, some suggestions how that might happen.
This whole thing has been a convoluted affair.
Yes. We're trying to do
One of the
things.
things I thought after the fact is that this thing should have been organized based on the issues, not on the articles, because everybody's trying to say, does this fit? Do I want to serve here? I don't know. I know the issues that I'm interested in, but I don't know that that fits this article, but I'll say, yes, I think it might. So then you go ahead with that idea. I thought it made it more complex doing it this way. But you've done it before, maybe this way. I don't know.
Glenn, can you please use the microphone?
Oh, I'm sorry. I just think it would be simpler if we did it by issues than by articles, because then we know what we're interested in, what we're talking about.
Steve?
I would agree with Glenn on this, because I'm interested in this reconveyance issue, but I have yet to hear what article it even should be under. And so I don't even know which one I should go to even talk about the reconveyance. And so it is problematic a little bit on some of these issues, because they could fit in multiple ones, and probably the prosecuting attorney will decide which one it best fits under. And so sometimes it's difficult, because I don't know where they fit and what meeting you should even go to or sign up for.
Other comments? And there's Steve, you had a suggestion earlier on about ways that we could improve the notification prior to committee meetings. Did you want to talk about that?
Yeah, I just think each committee should have somebody maybe that's assigned to take notes to put the minutes in, and maybe someone else that's in charge of scheduling that meeting. And so it wouldn't be, all the burden wouldn't be on one person, but it'd be on 2 people, one that does the minutes and one that does the scheduling, so we know, make sure everybody's been contacted if there's any conflicts. I think that would be helpful. That doesn't really address the issue of doing them by articles, but at least by the committees, no matter how they're formed. I think it's important that we're a little bit more organized than what we are currently.
Okay. So, Rod?
Well, and I think with Article 1, 2, and 11B, 1 and 2, there's reports, though, and 11B, there'll be a report for this evening as well, given out. Sue volunteered for those. I think the issue that arose was we had 2 members from the other committee sitting there going, well, we'd like to join you.
I could come 5 minutes.
Well, I know, but Article B, we gave notice, total members of Article B, that we're going to be there. We gave notice that this is what we're going to meet at, the time, limit, and our location. We have 2 members who joined us. I think, you know, when you're looking there, there's 4 members and 2 members wants to join. I don't think we can turn a commissioner away as an elected official. I don't think we have that police power.
Well, I consider the issue of 11 dead, because we voted on it, so we can move on. So it's okay. What I'd like to add is ask if under Article 1, if someone would like to raise their hand and volunteer to be the point person. So Sue, you want to be the point person for Article 1, okay? Who's the point person for Article 2? Steve. Article 3, Article 4A.
I have a problem with that.
Oh, Ted, you called us. Do you want to be the point person? Okay, you already called that. We have that one meeting. Article 4B. So if I hear no point person, does that mean that committee doesn't want to meet?
I'll do that.
Okay.
Because we've met, so we got
All right, Article sent the email out, that'll be me. 6B, Glenn? 7? That means 7 doesn't want to meet?
Has 7 met?
No, we haven't. How did we miss that one?
Ron Dowd, Ted Miller, Rod Pleck, and Don Corson.
No, we have not, yeah. To my knowledge.
We haven't. Okay, I can do that one.
Okay, Rod. Article 8. Connie. Article 9.
Well, Article 9 and 10, Barb Christensen's not here. She kind of did the notes from the last meeting that
Okay,
we had.
so you think she'll do it?
Yeah, I would agree with that.
Okay, so you think she'll do it for
That's right.
9 and 10? All right, I'll tell her she volunteered. Article 11A, I forget, am I A or am I B now?
Well, you're the last one at A, so you can be the point person.
No, I don't even know what committee if I'm an A or a B now. Am I A or am I B?
You're A.
You're A. And I'm gonna scratch Nola and Ted and Maggie off of A, right? And we're moving Celinda up. Okay, I'll do that. B. Okay, add Sue. B. And Marcia 12.
I'll do that one.
Glenn?
Yeah,
Okay, all right. So that should help a little bit. We know now who's responsible for calling the meeting, setting the time, date, place. Yes, Noah?
I needed to find out if, in our discussion, there were 2 of us that attended the Article 6, that were planning to attend the Article 6, that are currently on Subcommittee A. For the convenience of the meeting, we wanted to do it, we wanted to move to Subcommittee B, which is scheduled to meet tomorrow night.
So what you're telling me? That you are moving to B?
I would like to be able to move to B. I believe Sue was going to try and do that too. I'm not sure on my notes here. But we have not, again, heard anything from Subcommittee.
I sent an email out.
So we met with that group, and we didn't meet with that group. That group had not had a meeting yet. They are going to have their first meeting tomorrow night. I have heard nothing from Subcommittee A before that decision was made. And I'm comfortable with on the same page.
Well, I brings up the same issue. We end up with some inbound. We've got 6 on one, 3 on the other. So what do you do for minority report? But if that's how we want to function, that's how we'll do.
We had that same problem on 4. There were only 3 of us there. So only 3 of us attended. We are stuck with that rule unless we
That's why we
have
have
a
to meet
minority
again.
in one person.
But that's why we have to meet again. Because there are only 3 of us, so it didn't work. So anyway, yes.
We could change the rule to have a minority report of 1 rather than a 2 in order to accommodate the smaller subcommittees.
There are 3 of them that are small.
I mean, I think if a committee doesn't bother to email in 3 weeks, probably they don't think it's important enough to meet. So maybe that, those people should stand down or something.
Or maybe they've been doing other things.
No, but at least an email would say, I'm doing other things and can we meet, but no communication.
Okay, so where are we now? Is everyone, are we sort of going to just plow like we've been doing with these changes? Okay, as long as I know what the commission wants to do, as I say, you'll have to put up with me because I'm very much a process person. And once this commission makes some kind of decision, then I think it needs to hold. And if you want to change that decision, you need to come back to the body as a whole and ask for that change. Instead of taking an action and then coming back and asking us to bless the former action. So that'll be my last word on that issue. And Ron?
Yes, one article was missed, Article 13. I'm a committee person. I've met and I'm going to make my final report.
Well, I knew you were going to report tonight, so I didn't have to ask.
Is there a minority report?
There are no minority reports, except my wife who criticized.
All right, so if I hear no other comments. I think it's time to move on to these committee reports we're hearing so much about. Okay, so why don't we just go ahead and call them by number. So if you'll tell me if you have a report and is there a piece of paper we should find here or what? So Article 1, who is speaking on behalf of Article 1?
I am.
Okay?
The Article 1 committee met on March the 26th at 5 p.m. at Bella Rosa. Present were myself, Nola Judd, Ted Miller, Megan Roth, Glenn Wiggins, Connie Beauvais, and Ron Fleck. The topics for discussion we gathered from public testimony, and these are the items. One is...
Sue, are you reading from something
Yes.
we have here?
Yes.
Okay, so let me find it. Sorry to interrupt.
It's entitled Report from Article 1.
Thank you. Do you all have that?
Yes.
Well, Sue. Okay. Okay, go ahead.
Number 1, substitute coordination for cooperation in Section 120. 2, change Section 130 to resolve the inconsistency between Section 110 and 130. 3, the Wisdom Council. 4, privacy issues, government surveillance. On number 1, substitute coordination for cooperation, and add, county will require all federal and state agencies to obey all applicable laws, including managing all federal and state public lands in accordance with the law, Section 120. This issue was addressed by County Commissioner McIntyre when he talked about needing a policy mandate for better standing with state agencies. It was also addressed in the Grassroots Coalition platform, and language has been used from that submission as a starting point for this proposed amendment. Coordination poses an equal, not subordinate method of government, whereby the county would have equal say regarding proposed regulations that can adversely affect our local culture, economy, and way of life. In researching this issue, I find an ordinance written and passed by Benton County, which might serve as a guide for our own county commissioners should we move this proposal to the ballot and it passes. Discussion over way to word the proposal. Rod came up with some better wordsmithing and will send it to the subcommittee members for further discussion. Rod's language proposed for discussion: substitute Section 120, intergovernmental relations, as currently written with the following. The county and its officials should, may, will exercise their powers within this charter and applicable laws in such a manner as to ensure a coordinated response with state and federal agencies on those issues that impact the citizens, the economy, and/or lands within Clallam County. And we will be discussing that at our next meeting. Number 2, change Section 130 to read, the powers of the county shall be limited to those specifically granted in this charter. Delete the rest of the first sentence, remainder of section unchanged. Ted commented that without this change, the broad authority granted to the voters of Clallam County under 110 is taken away, and we become in essence a non-charter county. There was discussion, and this has been added by an amendment. Rod wondered what took place at the time that amendment had passed, 1981, and why it was believed to be necessary. Connie will look at Clark and San Juan County charters to see about language as a guide and report at the next meeting. Ted's proposed language for Article 130 for further discussion, as reported by Rod. Quote, when interpreting the charter and its application, the county and its officials will ensure that any interpretation, unless prohibited by law, affords the county those powers granted to charter counties by the state of Washington. Number 3, NOLA brought the idea of a wisdom council, which had been presented to the commission. This issue is being considered under Article 12 by that group, so it was tabled for this group. And number 4, NOLA presented a proposed amendment to prohibit all local government surveillance of people and private property without a search warrant. Rod pointed out that we do have the 4th Amendment to the U.S. Constitution to protect us from this. Rod has proposed the following language for further discussion. New section on privacy for general discussion / consideration by the larger committee. Quote, the right of privacy in one's personal affairs is essential to the ideals of liberty, and as such, the county and its officials will ensure that such a right is recognized and protected as established by the state and U.S. constitutions. End of report.
So how do you want to handle these committee reports? Do you want to just hear them all, or do you want to hear one and set aside 5 minutes of discussion, or 10, or how do you want to proceed?
Madam Chair,
Glenn?
I just want to say, I was listed as being at that meeting, but I left and came back. I was not there at this meeting.
You're not on one?
No, not at all.
Okay.
Do you need Glenn?
The other point that I would have made is if somebody in the commission wants to discuss anything that was just read, I would think we have a few minutes to do so right now. Don't you?
That's committee reports. Do you want to have the report and then have a limited time frame to have some discussion? And what time frame do you suggest?
Well, what would the purpose of the discussion be? To decide whether to move it forward, or just to ask questions? Or
Ask questions and do whatever you want.
when are we going to actually decide what to propose for the ballot? I guess I'm really confused on how we're going to move anything forward.
What we need to do is take these recommendations and that we need to look at creating proposed charter changes prior to the first public hearing of June 1st. Because that's our obligation, is to take to the public some real proposals. So the more that these can be into an actual proposal, then the better off we are. We can't just give a huge laundry list and say, come to the hearing and do you want to discuss the following 30 items. I think we need to hone them down, as I've said before. We have to be cautious and judicious about not, I mean, I think one thing that will happen is you begin to meet 2 or 3 times is that you may end up with 5 or 6 changes you want in a single article. Then you multiply that by 12 articles and it becomes obvious we have too many proposed changes. Then you begin to winnow out what we consider to be small changes. Because it doesn't work to put
That's
20
not really
things
what
in
I was
there.
asking.
So
That's how we're going to get there.
All right, that's up to this commission, is I am not your benevolent dictator, I'm just your chair. So you guys need to help me figure out what process you want to use to get us there. So Ron.
Well, I would suggest that each committee try to have, by the 18th of May meeting, all their proposed changes. I don't have a problem having a thing that goes out to the committee, to the public on the 1st of June, saying these are the 28 things that have been talked about by the committees, and you, the public, respond to those and give us your thoughts and whatnot. And someone will say, we don't think that's a great idea, or we like that idea, or what were you thinking? And then you come back to the meeting in July and say, okay, committees might go back and say, of the 5 we put forward, we really think 2 should be considered by this commission for a vote in July. And as to determine whether or not in August, those will rise up to the top out of the whole committee's work to put on the ballot. So it's kind of a winnowing. I think there's more of a role for the public. If we do give them 30, and they're like, we don't like this, we don't like that, well, okay. We can come back to the committee and say, well, okay, let's not put those 2 forward, or let's change the wording, or let's see if that makes it out of the commission as a whole.
I have a clarification on these reports, is that when they're saying the proposed language, was that a unanimous or a majority decision to move that forward to us to look at, or is that?
No.
No, this is simply the initial discussion of language, and when we go back to our committee, in our next committee meeting, we will discuss this based on language that has been done.
Okay.
And Steve raised a good point, when you do submit your reports, it should show what the vote count is, so we know if it's a minority or majority. And you may want to, and when I look at this, I think of when you have this discussion that Rod says the U.S. Constitution already protects us, you have to wonder then, do we need to get extra language into our charter if we already have one level of constitutional law? So
I would argue that's why we need to come and say, that says there'll be further discussion.
Right.
See, there's a key word in there, people. Please listen to that. So
that's my point, Mayor. Our discussion as a committee of the whole, I feel like should be directed. Are we supposed to provide comment and feedback to the subcommittee?
Yeah. Yeah, since you're not on the subcommittee, do you have a comment you want to make?
Well, I guess, I was a little reading the report for Article 1 and 2, they almost looked like they were being pushed forward for inclusion on the ballot. And I guess I was sorry not to read any discussion about it, any more in-depth discussion, any consensus within the committee of the value of it and those kinds of things, because I felt like that was the purpose of the subcommittee was to, I thought the purpose of the subcommittee was to both look at the article in general and provide some analysis to it, not just simply look at potential changes that have been raised by commission members or the public, and to take both, take a general analysis of the article and its appropriateness, look at recommendations or suggestions for changes, and provide analysis. And I don't really feel like I'm reading analysis here. I don't know, maybe that's just me.
Okay, Sue.
What we did was take all of the comments that have been made by the public so far, and that we believed belonged under this article, and that was what we were discussing. We represent the people. So that's what we're discussing, is what their desires are.
Noah?
Your original question was how we wanted to deal with this, and I'm thinking that this, after each presentation, the discussion period, I think is helpful. But then I think we also need to remember that this was, I believe in all cases, just the first meeting to give what she had indicated, to pull together what we thought we had heard, and then we'll go into a depth discussion on it. But I think this is good.
I would like to ask the consensus of the board when we have, figure out what our process is tonight. When we have, like Sue just gave a report, how much time do you want to allocate for general discussion by the commission? Remembering that 3 hours is our time limit for the whole meeting.
I suggest 3 or 4 minutes.
Thank you. Does anybody else concur?
Sounds good to me.
All right, so we'll do 3 or 4 minutes with a max of 5. So if I hear any comments from people that have not commented on this, Mike?
Well, some of these matters are very serious matters, and to do it in 4 or 5 minutes with such a long list of very important matters, to me, is a bad process. I know adding a lot of discussion adds a lot of time, but if you're going to come up with, say in this case, 6 major matters, one of these alone, you could take, I don't know, an hour, one night, come back with more. Now, if the subcommittee came up with pro and con and cited actual case law, statutes, studies, science, whatever, that's a start. And there is that documentation on some of these issues. But on one where, for instance, the name of the group, there was a grassroots coalition platform. I don't know what that is. I don't know what the interest groups are behind it, but in some discussions with boards of commissioner groups, there are some large corporate interests promoting something. And I would like to know what interests, what special interests are behind some of the issues. This doesn't have that.
Just in response to that, this was the first meeting, and all we did with these, at least in the committees that I was participating in, was to pull together the things that people had brought to us. That's it. The next steps will follow. The research and all of that. Pros and cons, weighing the pros and cons. This is just the first step,
So if that's the case, then I guess I would suggest we wait until all the research, pros and cons, is submitted ahead of time, I guess, in writing, so we can have a lesser time discussion, having done our homework and read it before we come to the meeting. But for instance, in this one, I've sat through meetings where commissioners from Utah were funded with public money, but they were really representing timber, grazing, mining, certain specific interests that wanted to do things with public lands. And there were other interests behind that. There are another whole set of interests that want to preserve public lands for public recreation, public revenue for schools, whatever. And that discussion just isn't here. But hopefully in the future research, we'll get both sides. That'd be great. I'd say the substantive discussion comes when that information is in front of us.
So we don't come to you, the commission,
Just
until
a
that?
minute, Glenn's raised his hand.
Well, I just think that, I realize what Mike has said is correct, that this is a very broad subject. And I think all we can do here is 5-minute thing, is to see something that stands out to us that doesn't fit, should be eliminated or corrected or something like that, and so we can move on. Then there will be another committee meeting by listening to those comments from this broad commission. There'll be another subcommittee meeting, and we'll come back with something more specific that you can throw rocks at here. Isn't that what we want to do? Is it clean it up, winnow what you call the winnowing?
Yeah, but I think it's also important that we all have some philosophical discussions and that we have pros and cons and that we show that we've done some research. Because it's fine for someone to come and give us their point of view, but it doesn't mean that you have to take that individual's view and then translate into a charter change.
No.
So it's a much broader discussion than that.
Okay.
Yeah. So I think Nolan had her hand up. Do you have your hand up, Nolan?
I did, but I've lost my thought now.
All right, okay, Madam Chair. So, yeah.
I'd just like to point out that I think for at least this particular commission meeting, we're just bringing to one another what we've been discussing. You know, so everybody knows what topics are being discussed by the various committees.
And we're just fumbling through, trying to figure out what we're doing. So we're making up as we go along here, but we're trying to get some rules for ourselves, so, okay. So Ron, and then we're moving to our...
Yeah, I would generally say that's correct. This is just a kind of a first cut on all of this. But for 13, I'd like to make it finished.
You're done. So that we can do a motion to reconsider?
Yeah, no reconsideration.
All right. So,
That's what we need.
we will take Article 2, and then we're going to have a stand-up break. And then after the stand-up break, Mark, you want to make some comments to it, did you?
Yes.
All right, so we will do Article 2, have a 5-minute stand-up break, and then Mark wanted to make a report to the commission too. We'll throw that in here.
Okay,
So 2, who's reporting on 2?
I am.
Oh,
You get me
it says here Steve Burke is the
Well, he will be.
He will.
Do you want to read it?
There you go.
Now, what does that one look like, Steve?
I'm sorry?
What
It
does
looks like
look
Article 1. But it's Article 2.
We're on Article 2,
I know, but I'm looking what your piece of paper is like.
just like Article 1, except different words. That we met on the 26th at 4 p.m. Bella Rosa, thanks. And you can see who all was there was Sue Ford, Rob Fleck, Maggie Roth, myself, Celinda Barkhouse, Glenn Wiggins, and Barbara Christensen. The topics that
Where did we
we...
meet?
I said those.
Okay.
Topics that we...
Our chair does not have the paperwork in front of her yet. I think that's doing her a disservice.
I can wait.
I don't have it. Do you have it?
No.
Thank you. Oh, okay. It got passed down to the empty chair. Thank you. Okay, thank you,
And
Ellen.
we also, on this one, pulled some of the public testimony to determine the topics that we would like to address in this subcommittee, and they were the Citizen Salary Commission, the commissioners limited to 3 terms, the commissioners shall hire administrative assistants for clerical support, that we would look at 5 commissioners, 3 from District 2 at large, then just 5 commissioners and 5 part-time commissioners, an elected administrator. We also, the 7th one was vote for a commissioner by district, and the 8th one was public meetings to be videotaped. And on the, we discussed all these. We haven't researched like the Article 1. We haven't gotten into the nuts and bolts of any of these, but we just decided the framework from what we wanted to look at. We decided under Article 2 that the Citizen Salary Commission should maybe just go forward to the commissioners as an advisory to have them do that by resolution or by ordinance. And since all of the commissioners are in favor of a salary commission, them doing it by ordinance would relieve us from having to put that on the charter. And they have the same authority that we have, and so they could do that by ordinance, and it would look the same. And so we decided we wouldn't be talking about that one anymore, at least on this subcommittee. And the rest of them, we're still talking about. None of them percoled up to a decision yet, and so we're still looking at those. But those are the items that we're going to look at.
Thank you. I think, you're grouping those as issues is the kind of thing you could present to the public during the public hearings for their comments, because it's a kind of general descriptor instead of changing line, blah, da, 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 da. I mean, so this is sort of some discussion promoting language. I think it's helpful for me, and I think for a public hearing process, people could look at that. Open for comment. Ken?
Yeah, I guess part of my concern with our discussion on Article 1 and as well as this is that in the overall time frame, I think we should be winnowing as best we can as we go along. And so regarding Steve's report, I mean, I don't see why we couldn't, I think it's a good recommendation on number 1. Can we just take it, this is sort of a question about process generally and this specifically. But is there any reason we couldn't see if there's consensus tonight to drop this from discussion so that they don't have to spend so much time on it?
So what are you asking, Ken? Are you asking the
Well, these
number?
guys, the Article 2 committee is basically recommending not spending any more time on the salary commission, but to forward it to the commissioners as something to work on administratively, right?
Okay.
Yes.
And I think that's a really good idea, because I don't think it's one, if we're really gonna limit ourselves to 5 or 6 ballot items, this probably isn't at the top of the list, I'm pretty sure.
Well, you're free to make a motion anytime.
Well, so there's a question, is that something, how would we do that? Do we make a motion and vote on it, or can we do it by consensus?
We could do it by motion. By consensus.
Well, I would move that we accept the Article 2 committee's recommendation that Citizen Salary Commission not become a ballot item, but be forwarded to the commissioners for their consideration.
Is there a second?
Second for discussion.
Seconded by Ron. Any discussion? Connie?
I'd like to know if the committee talked about having a salary commission just for the commissioners, so that they're not put in a position of setting their own salary for their entire term, or they set the salary before they leave. It would, to me, it would provide a little more transparency if there was a group of citizens who were, told kind of how much money there is available to set their salary, but that the commissioners could set everybody else's salary.
Well, I think how we discussed it was that because the 3 commissioners have said that they're in favor of the salary commission and would prefer that, that salary commission would cover them as well. And so the salary commission would cover all elected officials.
Yeah, we're not abandoning the salary commission concept, we're pushing it back to the commissioners to decide how to deal with it.
I would just like to make sure that in our kicking this to the commissioners, that we give them some guidance of what we would like them to do, so they had something to chew on.
So you do need more time to talk.
I think Robert's rules say that we should address the chair, not each other.
There you go.
There you go, Carly.
Hey, until someone calls for a rule, you all get what you want.
I said you probably get to us on this. Thank you, Lola.
Well, speak.
I know, I'm calling you. I just want to have prerogative of the chair. Basically, the tone of if I get you right, the motion is that basically take this off consideration and be on the ballot. Look at making a recommendation to the commissioners. Now, it does not preclude you from making a pretty specific recommendation. That you could work on. I mean, you have this, I asked Jim Jones to give his memo to all of us, his homework he did on the 3 different ways that you can set up salary commissions. So I think your general, if you're your motion is pretty general, it just means it's gonna be a recommendation, specifically what the recommendation will be, something we have to work on and vote on later. Am I reading your motion correctly?
Yeah, I guess I would be willing to withdraw the motion. I'm not sure it's appropriate, but I think I'm hearing now that more discussion needs to take place.
Okay, and who was the seconder? Ron, do you want to withdraw your second? Okay, so it's off the table. So you've heard the senses. Now, Nola?
I move that we submit to the commissioners this input from Jim for their consideration in coming up with whatever that proposal is they come up with, rather than having our committee consider it. I think this is homework that's been done very carefully, and I think with that the commissioners could make a decision.
Well, except I think what you're hearing, Noah, from the discussion here is the committee wants to have a little more committee discussion around this issue, and this is a good information. Right.
Gotcha.
Right.
I rescind myself.
Okay. So I think, are we completed with Article 2? We'll take a 5-minute stand-up break. We have like 10 articles left. We need a little space for a good of the order and a little space for any additional public comments. And Mark said he needs about 5 minutes. So just keep that in mind. If you feel like I'm pushing on you, that your discussion of the articles is just an attempt to get through them. And if we don't get through all of them, then we'll just have to add that on to the next meeting's agenda. Okay, so Mark, you have a couple comments you want to make?
Yes, thank you. And so I just wanted to follow up, consistent with our last meeting, and bring back before the commission the question that I'm planning on submitting to the Attorney General's office, along with a request for a formal opinion. And so consistent with the discussion and a comment made by Rod, I believe, that should trigger peer review within the Attorney General's office. What that means is we'll have more eyes and more minds focusing on the issue, which I think is helpful. And it also makes the opinion one that's going to be paid more attention to by county jurisdictions across the state. And so the question that I'm planning on forwarding is essentially the same that was previously discussed and brought before you. And it reads, may a county operating under the home rule form of government convert the office of county prosecuting attorney from partisan to nonpartisan via charter? The time frame on the AG's office answering this is an unknown for me right now. Once I submit it, I'm going to talk with a gentleman named Jeff Even, who's the head of the opinions section in the Attorney General's office. I'll let him know that to the extent they can expedite this, it would be appreciated, but they've got some staffing issues. This is going to be an issue they're going to want to thoroughly vet, and so I wouldn't be surprised if, consistent with the discussion, it takes more time than we have available. And so, Madam Chair, I see a hand or two coming up here, and I'll let you call the questions.
Ron?
Well, my question would be, Mark, is whether or not if we could, in his letter, he could incorporate some, we'd love to hear back from you by the 15th of October. That would give the Charter Review Commission the ability to come back and, if not by August, to come back and then address, at least talk about the letter before our term's done.
That sound reasonable?
I'm glad to build that in. I think that'd be helpful. It's nice to actually have the opportunity or the possibility for closure on the issue. And so I personally like to learn the answer myself through the lens of the Attorney General. So I'll build that in unless I hear a strong dissent or objection from the majority.
Sounds reasonable. I assume the consensus is that sounds reasonable because we do have the capacity, even though we have to have our language into the auditor by the 1st of August, we do have the capacity to come back if we wanted to put something on the ballot in 2016 to come back and consider that. That's what this would be. Ted?
I just wanted to echo my complete agreement with Ryan. I think that's a very good idea.
Well, I'm just assuming the consensus is that sounds like a good idea. Is that correct? Nodding heads. Okay.
Great. And then the other matter that I wanted to address is one really for the good of the order, and I think it's inextricably intertwined with the discussion that you had about your committee work and/or extent there are legal questions that are developed by a committee or a subcommittee, or frankly, even an individual charter review member, and there's a desire to have those forwarded to the county prosecutor's office for consideration, what I would ask, just so we can employ kind of a funnel effect, as it were, is that those be brought back before the commission as a whole for discussion here, and then if I hear 8 or more charter review members join the request to have that issue forwarded to the county prosecutor's office, I'll look at the legal issues that are presented and then go ahead and render an opinion back to the commission as a whole. And in that fashion, I think will, from my perspective, it's going to wind up cutting down the number of possible requests. And then everybody on the commission is going to be on the same page with respect to the role of legal counsel, because I don't want anybody to be surprised by any opinions coming out of the prosecutor's office or feeling that they were somehow left out in the request being made.
Ken, a question?
Mark, hearing you say that concerns me, 'cause I thought we had already agreed to do that, so it's not the overburden. Have you been getting requests, independent requests for?
I think I've received some questions that triggers the issue in my mind of whether everybody understands how I prefer to have work.
I thought we'd had that discussion.
Sometimes attorneys are less than clear. So I thought I'd revisit it.
We need to respect your time.
These are fascinating issues to research. They're really important. But the reality is that with all of my statutory clients, what takes 15 seconds to ask can take 15 hours to research and answer, just depending upon the issue. Some of these, fortunately, are going to be fairly quick and simple to answer, I think. Others are going to be much more elaborate. And so, again, that would be my request, is to have documentation come before the commission as a whole, the committee as a whole, and then following the majority vote, something can be provided to the clerk, and she can scan it and email it to me. That way we have a nice process for following with the paper trail. The record is reflected in that, and it's borne out following discussion before it gets approved.
Okay, so to revisit, remember, it has to be a majority before it goes. So if a subcommittee meets and there is a question you think bubbles up and you'd like to have the prosecutor consider it, it needs to be part of your committee report. That's an issue you think you'd like to look at some, and then the whole group will have to decide if that question bubbles up to the point where it should be submitted to the prosecutor. So is that clear for everybody's? We're sort of making these rules as we go along, making our committees more succinct. Okay.
And then the only, I think the concluding comment that I have is to factor into your considerations regarding time frame on when you want to have your work done, the fact that it will be very helpful, and I would submit necessary, to have proposed ballot measures sent to the prosecutor's office well in advance so we can vet the legality of what's being proposed on the one hand, and then also help craft the language itself so we have something that is lawful, that's being presented to the voters, meets word count requirements, enforces the single subject rule, subject and title rules, that sort of thing, so that your work is being brought before the electorate properly in a way that's lawfully defensible, and it's going to hopefully lend itself to a more informed electorate at the end of the process.
Our schedule calls for us having finalized language July 20.
I think that'd be great.
Mike?
That was going to be my question, had he reviewed the schedule to see that that date is adequate, and maybe we don't need August 30.
August 3rd is, the July 20 is the language when we send it to Mark, and then when he brings it back to us, then we meet and we look at what he's done, so that we know exactly what's going to that. So we're all apprised of what language is going to the that.
So would you take segments of final language to let you have more time to do the research and come back to the board? Say language regarding 3 different articles. You know there's possibly 3 more coming, but at least you have some advance time to look at it over and not have a deadline at the very, very end, rather work on it.
Sure, I'm going to given the multitude of ideas that I'm hearing being brought forward and discussed as between the commission, right now I'm trying to let the winnowing process occur so I can get a sense of the issues that are likely going to require some legal research. And so I've got my folks and myself kind of in abeyance. We're looking at likely issues that are going to wind up withstanding muster through the process. And then once I start getting some clear direction that there's likely going to be significant interest by a majority of this commission to see a measure placed on the ballot in relation to a particular subject matter area, that's when we're going to really start digging in on it. If there's something that I hear discussed that just strikes me as an absolute non-starter, it's illegal, for example, I'm going to interject myself and just let the commission know that I think that you're going to run into a legal roadblock, and there may not be great merit in putting too much time into a particular issue. And so, I mean, just as an example, earlier this evening, the topic came up involving essentially search and seizure. And so, while you could choose to address that if you wanted in a county charter, the reality is that in the United States Constitution, we've got the Fourth Amendment, which circumscribes and puts in place protections when it comes to search and seizure. Washington State's Constitution goes even further than the U.S. Constitution in conferring even greater protections. And then there's a labyrinth of court opinions and statutes that can be read in conjunction that collectively fashion a net of protection and security around personal privacy interests and the like that require enforcement officers to obtain warrants through a process. That may be the sort of issue, I'm not saying you can't explore it through the charter, but your time may be better spent on a different area where there's maybe not as much guidance and law already in place. So that's an example of an issue I'm probably not going to spend a lot of time researching right now.
Noah, and then Glenn, and then I think we're ready to move on.
I noticed that Article 1 and Article 2 had some specific language under consideration, and I don't know if you get copies of this information or not, but if they are ones that are totally out of line, would you let us know before we delve into them any deeper? Or do we have to come back here again
You would
to
need
do that?
You need to come back to the commission because there has to be a majority member on this commission that wants that issue to have reviewed by one.
I'm going to wait till 8 or more Charter Review Commission members ask that a matter be directed to my office before I really start focusing on it. Just out of necessity, because otherwise I'm going to be left to try to sift through the volumes of documentation that are coming in and guessing at what might make its way through the process. And that's, frankly, it's not something that I can do with the time available. Amongst other obligations, and so I'm going to rely on you as a group to provide me directions to what you want me to look at.
So the bottom line, though, is remember you have to have 8 Charter Review Commission's members say this is an issue we want the prosecutor to look at. So that's why it can't ever come out of a subcommittee because you can't have more than 7 on a subcommittee.
But
does that answer it?
well, sort of, because we did present some of this information to the group, but we didn't ask for a vote on any of those items because we are in a preliminary stage. But at some point, we're going to be getting so close that even preliminary stuff is not going to get to the whole group.
Well, that's the secret, is that we are preliminary, and so we'll win on. We'll get there.
I have your word for that,
Yeah,
right?
I guarantee you we'll get there. Glenn?
I was thinking about this, also Ken pointed out, this winnowing process is something we need to get through just for the purposes of this sort of thing. If each subcommittee would give an order of preference out of their committee as to the most important things that's coming out of their subcommittee at each report that we have, that we receive here from now on, would that be of some help?
Yes, I think it would be. Okay. I think we do have time constraints, so we need to move on. You have one more question, Nola, then we're moving to...
As a part of our discussion after each of these are brought up, then can we make that a part of that discussion, that we get a consensus? If there is no consensus, we won't spin our wheels.
I think the bottom line is that all these committees said, this is our first report, we're gonna meet again. So why don't we deal with that after you've had another chance to, you just done one cut at the apple, so I think. Okay. Any other? Mike?
Okay, this is just a concern, but I think the prosecutor should get some other advice. Maybe it's the next meeting, but tonight there was a vote to take a final action on an item to give it back to the county commissioners, for instance. To me, that's a final action. The discussion was, great, it's final, we're going to do this. There was no notice to at least 2 of the CRC members that final action was going to be taken tonight. So I think we have to be cautious, maybe have a point on the agenda as we finalize things. We put it on the agenda.
Point well taken.
So all members know they ought to attend if they're present.
Right, thank you. Okay, any other comments? Thank you, Mark. Article 4, Subcommittee A, we met, and we're going to meet again because 2 of our members could not attend. So, Article 4, Subcommittee B.
We did meet at Camaraderie Cellars. I would have to say that that's a very good place to meet.
We're all jealous.
And I won't say I didn't know what we were talking about after a while. We talked a little bit. The only thing that percolates up in 4 is the DCD. And the majority wanted to move that forward for it to be an appointed position. And the minority of that wanted to just put forward that it would be elected but with qualifications. And so those are the 2 kind of things that we're talking about in that. And the other issue we talked about was this proposal for a charter enforcement commission, and it's in your packet, and we were unsure where that would go, so we called it Article 14 for now, but it might go in 12 or wherever. But the discussion was that we really don't have any mechanism to enforce the charter. If a county commissioner or any elected official chooses to not to do something, unless someone takes them to court, there's really no way to enforce abiding by the charter. So it was talked about, well, we need some type of enforcement mechanism that can assure that the elected officials are following the charter. And not only just elected, but department heads or whatever. And so this was kind of synthesized by other home rule charter counties that have enforcement charters, and kind of tailored to how it would fit in our, and it's just a draft proposal. We're still discussing it, but it's just out there so people could take a look at it. But the idea is to come up with some kind of mechanism that can enforce what we ever pass as a charter, that there's some way to enforce it and have teeth, actually.
Just for future reference, when you send something, be sure it's noted who sent it. We didn't know where this came from.
Okay.
So, I mean, I need to have a name.
And it is included in the agenda packet, I saw people looking for it, so it was part of your agenda packet.
It's titled Proposal for a Charter Enforcement Commission.
Okay. Yes.
Was this something that just the committee came up with? I don't remember hearing any of this in the testimony.
It was just something that the committee came up with, talking about, well, how do we even enforce the things that we do have even on our charter now for people to follow? And so we talked about it, and it didn't fit.
Need to be discussed. That's why we're elected, to have that kind of discussion. We can hear from the public, and we can decide to try and incorporate it or modify it or not incorporate it. But it doesn't mean when you have the subcommittee, the only thing you talk about is what you heard from public comment. So, does that make it clear?
I'm just concerned that the public perception might be that we came to this with hidden agendas. I don't want that coloring to go out. And that may not be what's happened, but it sounds like that to me.
Well, I think people of open minds can look at the charter, and people cared enough about the charter to run. so if they had some issues or they have a concern, I think we have a right as elected charter members to raise those issues and concerns. You know, you can label an agenda if you want, but I would label it just concern and knowledge about the charter. So, anyway.
I just want to make a comment on Nola said. There's a difference between hidden agendas and open agendas. I campaigned on a particular issue and it's very clear to the whole public. So I do have an agenda, but I made sure that the voters knew exactly what it was when I campaigned.
So, Steve, do you want to give a real brief oversight of our Article 5 when we met?
Me. I'm not in charge.
I know, but I just made you in charge. Because you're young and have a much sharper memory than I do. I don't think we voted up, did we?
I was going to say, I don't see it in my packet.
I think we pretty much decided there wasn't a whole lot to do with 5. So we had some philosophical discussions about how county government should work. But we came up with no, if I'm recalling it correctly, we came up with no substantive changes to 5.
Yeah, I think that was also the article that we had talked about, the idea of a charter enforcement too. I think we talked on that committee as well.
Did it meet at the bar too?
No, that's why I can't remember.
Okay. We'll have to write, well, I guess nobody needs mileage for that one because it was held here, so, okay. Article 6, Subcommittee A is the one that has not met. There is an email in all your boxes saying you want to meet, but now, so that will happen later. Article 6B.
Well, I agreed to do that, but I didn't make the first meeting of that group. I don't even know if they met.
Okay.
I'm not sure. Is somebody here that met with Article 6? If not, I'll call a meeting and we'll have a meeting. Yeah.
So nobody knows whether or not 6B has met? Maggie, Steve, Celinda, Glenn,
Glenn wasn't there, so that now he's.
I do not believe we have met.
and Sue wants to go to that one, and Noel wants to go to that one. You haven't met yet.
We have a tentative schedule following the back-to-back.
I think it's tomorrow.
And I'm uncertain why we made those assignment changes in A and B when neither one of them have met.
Because they're meeting tomorrow.
We're meeting tomorrow.
One of them is meeting tomorrow.
I know, but the two people on A that belong to, have received an email from me saying,
Oh, that's true.
Article 6, when do you want to meet? And now I come and I'm told that they don't want to meet because they want to be part of the other committee. So I get
Already
a
met. You
letter.
were aware of that we have already met.
Well, somebody just told me you haven't met.
I thought that's 11, Norma.
No, this is 6.
11 minutes.
We're talking about 6. Because I get very confused. Has 6B met?
No,
Thank you.
I like to run.
So I have an did we change the committee assignments for 6A and B?
Yes, because Noel and Sue wanted to be on committee 6B because 6A hadn't met.
I thought that was
6B hasn't met either.
We have 5 meetings.
They did 2.
Tomorrow.
Oh, they did 6 as well? Oh, I'm totally confused.
Okay, fine.
Yeah, we have 2, 1, 11, 8, and 6
So
tomorrow
who's-
night.
Okay.
So there's a meeting for one of the subcommittees for 6 tomorrow night, which I didn't, am I still on that?
Well, you're on
subcommittee?
A. I emailed you because I sent out an email to committee A, which was Nola, Ken, Ron, Sue, and Norma. But then I came tonight and Nola and Sue do not want to be on A, they want to be on B. So the email you got is for subcommittee A. So which is now you and Ron and I only. So it's 3 on one and 7 on the other, or 6. So, you know, it gets an imbalance, but I'm not going to even go there.
But
That's
at
fine.
least you have a plan now.
I guess so. Thank you. So 6 hasn't met anywhere, anytime, so let's go to 7.
7 did not meet. We already said that.
Thank you very much.
But I
That was
don't want to be
fast.
on it.
That one probably needs a Lemoyne read. Might want to
I'm
join
thinking
that
it
one.
will. After this meeting, I'm pretty sure where I'm meeting.
I might
Okay, Article 7, committee has not met. I sent out 2 proposals. I just want the commission to be aware of them. One is on behalf of the county auditor and myself to replace the last sentence of section 7.50 to clarify the fact that we no longer have independent candidates. It states no party preference candidates. And it's really a housekeeping thing, but it is fairly important to make it consistent with the law. And the other is one on behalf of Sheriff Benedict, adding qualifications for the office of sheriff, which is obviously would be controversial. And that'll be something that Committee 7 finally does meet and discuss.
Okay, thank you.
Were you talking about 6 or 7?
He was talking about 7, but 7 hasn't met, so now we're doing Article 8. Okay?
So this is the Article 8 Subcommittee report, and Article 8 is the public interest. The Article 8 Subcommittee held its initial meeting on Monday, March 30th, beginning at 5 p.m. at the William Shore Pool Building in Port Angeles. In attendance were Steve Burke, Ted Miller, Sue Ford, Maggie Roth, and Connie Bove. Reviewing public testimony and written comments received by the Commission, we see no comments that would lend themselves to proposing changes to Article 8. Subcommittee members discussed streamlining the referendum procedure, and Ted would like to look at 8.90 recall with an eye toward making the process simpler. Following discussion, it was agreed that the members will review other charters in the state to see if there is cleaner language used for this article. Sections will be researched as follows. Steve Burke, sections 810, 820, and 830. Ted Miller, 8.40 and 8.90. Maggie Roth, 8.50 and 8.60. Sue Ford, 8.70 and 8.80. Connie Bove, 8.95. Members will discuss their findings at a meeting to be held Tuesday, April 7th.
Thank you. Any comments? All right, we're doing well. Article 9.
Okay, Article 9, I'll take because Barb Christensen is not here. And she sent an email to you, I think, and I got a copy.
Microphone. My password. Use the microphone, please.
Okay, Article 9, Barb Christensen, myself, Steve, and Ken are the 4 on that committee. We met, it was last Wednesday at the Bella Rosa, but there's only 2 people, that's myself and Barb, so we didn't have a substantive meeting. We thought that we needed to have the entire committee get present before we met, so, and started talking about things. So there was a couple of wordsmithing that we did talk about in the budget process, but that concludes really what was done in Article 9. Any questions on the budgeting process is what the wordsmithing would be. Yes.
Dave?
One of the things we did talk about in that is the idea of giving more control of the budgeting process to the elected officials for their area. And we did some research of other county, actually, whether it's in the state of Washington or not, and kind of how we do it is very similar to everyone that we or at least I could find, is that the elected officials kind of are, for lack of a better word, treated as a department head in the budgeting process. And to go beyond that, we would be unique in that process to give more authority to the elected officials over the budgeting process than what we have now. And so that was one of the things that we did look at, is how much, is there a way to give more authority or not to the elected officials over their budgeting than we currently have. And it seems to be if you go that extra length, that we would be out of the norm for counties.
Well, thank you, Steve. You must have done some research based on that email. I appreciate that. I was looking at it, that maybe As I understood it, perhaps the county administrator doesn't consult with the department heads before making up that preliminary budget and meets after the preliminary budget, and it just seemed a little out of order to me, but I appreciate that. That's kind of what the committee's looking at.
And then Ron, you also reported on 10.
Yeah, I'm here doing 10, and again, Barb and I met on that, and we don't have any proposals to present at the meeting next week, but we are researching 10.40, and Norma's on, you're on that one, I guess.
No, I'm not.
No, okay, that was just a courtesy then that she had done. Who else is on?
It's just you and Barb.
Just, yeah, that's right, we're a two-person committee. And yes, and so we really had no substantive comments, but in view of the situation about asking the prosecutor about something, we may have a question, and that is about any public employee that's terminated can request a public hearing within 15 days. And first of all, I start being a little bit funny, but is there also going to be a violation of confidentiality in that type of thing? And I don't know, and again, that was one of the things we touched on very quickly, but we don't have any proposals.
Yeah, and Ron, I had written out something that I gave to Barb with regard to that section. I handed it to her the night the committees were formed. Can you check her to see if she got it? Otherwise, I'll try to go back and mentally recreate it. It came out of the conversation Mark had, a way you could address the confidentiality issue and still give the employee the right to make a decision as to which way it wants to go. It may not be what the prosecutor would have liked, but it might be what the employee should have.
Yeah, well, I will. I was not aware of that.
Article 11B.
So I have the report from that committee, you did. I'll read it. And so report from Article 11.
Before you start, Ron, what is that one?
It looks like the other two did. I'm sorry, no, my mistake. You don't have it because I was supposed to hand it out. I was running around passing out everything else.
Thank you very much.
This is 11B.
It's 11B.
And 11A hasn't met.
There you go.
No.
Yeah.
I was going to do before, didn't you?
That's because A hasn't met. They all abandoned me and went to
But she's not bitter about that. Okay. Article 11. Subcommittee meeting held on March 26, 2015 at 6 p.m. in Bella Rosa. And President, myself, Maggie Roth, Noel Judd, Ted Miller, Steve Ford, and Connie Beauvais. Topics for discussion of public testimony included look at commencement date for commissioner, term of home rule charter, review charter more frequently, election officials should not be able to run for charter review, proposal for a charter enforcement commission. So item number 1, look at commencement date for commissioner, term of home rule charter. Currently, the term of service begins certification in November and runs for 1 year. The recommended change would be to start the term on January 1st, run for 1 year through December 31st, and call the first meeting within the first 2 weeks in January. We'll put together some proposal language for this item. Item number 2, charter review more frequently. It was discussed about returning to every 5 years. Several constituents have suggested every 4 years. The discussion, the charter was elected in off years. The ballot items would be on even election years, wherein there was a lot of activity and would bring more voters to voice their decisions at the ballot. Look at possible language to hold the next Charter Review Commission election in 2015 and every 4 years thereafter. 2019, sorry. Back in time. Number 3, elected officials should not be able to run for charter review. Discussion about the perceived conflict of interest potential with those elected officials, county administrator, or charter exempt personnel whose positions are covered under the charter. I will put together some proposed language about this for the next subcommittee meeting for further discussion. The language submitted by me was 11-10-10. No elected county official, administrator, or charter exempt employee may serve as a member of the Charter Review Commission. Number 4, proposal for Charter Enforcement Commission. discussion about what role the commission might play in enforcement. It suggests that we call the county commissioners back to testify before the commission on this issue and give a response as to how they see enforcement. Respectfully submitted, Sue Ford and Rod.
So did you consider this thing that Steve sent out with charter?
We looked at it, and we also knew another committee was looking at it, and so one thought we had is trying to see what the three commissioners think enforcement should entail. And then from that, see whether to go something like this, or one other option we discussed was, well, maybe you just have the Charter Review Commission hold a term of office for 4 years, and if there's a petition for review for enforcement, the Charter Review Commission listen to that. But we were like, that's an interesting discussion. So we did not have the wine where we were drinking, and so you know, we at least said we should get some more information from the county commissioners and our opinion as to how they see enforcement being done. So that was the thought process.
Why would you
Wait. Okay, I see Ron's hand up, and then Steve's, and then Glenn's, and then Ken. Okay.
Yeah, I just let you know, I looked briefly yesterday at the Clark County Home Charter, and they do have a provision in there about elected officials not serving on the Charter Review Commission. It's a very short one-sentence article, but you might want to look there.
Okay, Steve, you're next.
What is a charter exempt employee?
So in the charter, I want to say it's Article 10. It's I used to know this one by heart. Yeah, it's Section 1020. It's the elected officials have the right to have an employee who's exempt from the personnel system. They're called a charter exempt employee, and they basically report to the elected official. And so the idea was, if you wanted elected officials not to be on the charter, having their hand-picked lieutenants that work for them exempt from serving on the charter also probably made sense.
Then Glenn, and then Ken.
I think we did have wine because I was at that meeting. I'm not listed on that.
I didn't take notes, so that's probably why.
So you read that one, but not at the other one, Glenn. Okay, so add Glenn to that one. Okay, Ken.
I guess I didn't understand why on proposals for charter enforcement, for a charter enforcement commission, you would want to have the commissioner's opinion. And isn't that kind of like asking the foxes how they want the hen house guarded?
I always feel it's worthwhile having the fox in the box. And if I can ask them questions, I'd love to. Many folks don't want to take that opportunity, but we should offer it. It's only nice and polite.
Any other comments?
That's how we ended up with
Okay.
an elected DCD director.
Article 12.
Okay. There are 6 proposals. You have it in front of you there. The first one basically was already mentioned here
Excuse me,
tonight.
Glenn.
Yes.
Hold up what we're looking at.
Okay, it's the minutes of 324-15, Article 12 Subcommittee. They were passed out, I think, by
Can you speak into the microphone better?
Oh, I'm sorry, yeah.
Did you not get those?
So, I found it. Thank you.
Okay. So we said, let's adopt the Kai Alberg suggestion on those 2 issues that you've already heard about. The grand jury idea we also discussed briefly, and that requires more study. The county trust land item there. And then there's a sheet that was sent by email today, and also you have a copy of it now, talking about the reconveyance of county timberlands, points to consider. You have that as well. Okay. So it's a large matter. It's one that Rodney's had a lot of experience with, and we appreciate the fact that he'll now serve on that committee, subcommittee with us. He's volunteered to do so. So I would just suggest that you read that over. It's going to be raised. I didn't hear from you, Sue, about the local control of imposed mandates. you were going to write some language, but perhaps didn't get to it yet.
Before our next meeting.
Okay, all right. And then Connie suggested Article 12.4, compensation by the community for impacts to property owners. That was also raised tonight, wasn't it? Yes. And then the final one was this language from this grassroots coalition, which Mike didn't know who that was, but I suspect it was an organization that put this forward. Okay, and it was mentioned tonight also. I think it was in Kai's, he presented that. So those are the issues that Article 12 Subcommittee discussed.
I have frankly not heard the term human environment, so I Googled it.
Yep.
And sort of the environment doesn't get disconnected from it. I mean, the environment is where people live. So I don't understand the term human environment.
The advocates will probably explain it. Go ahead.
Well, no, I had the same thought when I was hearing from Mr. Alberg. I mean, if human environment is different than the natural environment, does that make the human environment unnatural?
Most of the time.
I mean, I think it's ludicrous to separate it, frankly, but we can have that discussion later.
Right. That's what we are.
Thank you. Ron?
Yes, I just have one question on, and it may be a legal question, and how the Charter Review Commission handles something that is already covered by an RCW. But I looked up number 2, grand jury idea, and it's covered in chapter 10.27 of the RCW. There's about 6 subsections that deal with the grand jury process. So we do have it in Washington, and in this county, I would presume, because we're governed by the laws of the state of Washington. So
maybe it needs no further review.
well, that's what my implication of my remark is.
Thank you.
Yeah.
So that'd be part of the winnowing process, that if we're covered with some other sphere, then we don't need to get it into the charter. So, okay. Ken?
Well, I just had a clarification from what Ron just said. I thought what we had heard about was a citizens grand jury, which I didn't know what that meant.
Oh,
versus
okay.
a grand jury. So what are we talking about here? A citizens grand jury?
No, this grand jury that's referenced in the statute is that the prosecutor or another interested party goes to the judges and then they.
But this does just say grand jury. Is this?
That's maybe needs to be stated. I don't know. I'm not necessarily saying I've heard of it, the citizens grand jury, but wouldn't be the first time.
Well, I wasn't sure of it myself. I really wasn't, so that's why it requires more study. We'll dig into it. Okay.
Other questions? Steve?
Since Article 12 doesn't have the 7 people, is it a problem if I want to attend since the reconveyance of trust lands is being talked about there?
It is not a problem since other people have been joining. So you want to join Article 7?
Yes.
All right. So note that Steve Burke wants to be on 7.
12.
12, I'm sorry.
Yeah, and I would like to be on that, because when I withdrew from one committee, I said I wanted to deal with the DNR trust land one, but I didn't know where it was gonna end up.
So, Rod, you want to now be on 12 also?
Correct, yeah, I'm gonna try to.
Well, I want to be on those.
So Ken, you want to be on that one too?
No, I was kidding.
There's room for one more. So, okay. Now, Ron, we're down to Article 13 that you're already going.
Right, and I don't want this to be anticlimactic because I looked at Article 13. I was initially interested because at some forum I was at, one of the candidates talked about having a code of ethics specifically put in the charter. And so what I looked at was section 13.80, required ordinances. You see that I handed something out for you to read, but it talks about section 12. It says that the following ordinances shall be adopted by the county commissioners by December 13, 1977. So my conclusion after looking at this is it's really moot that those are transitional rules and they've already passed and presumably they're already happening, or they have not happened. As you say, it's a separate issue whether you want to put code of ethics in the charter, but that's not something that I feel belongs in Article 13, because those deal with transitional provisions. And so I said, as I concluded, I have no recommended, I do not require any substantive changes to Article 13 at this time. Whether it's still relevant, that's another issue too, but there's no changes to be made.
Steve?
Have these actual ordinances been adopted?
Okay, I was not, I sought I asked a couple of commissioners that I knew, former commissioners. They were not aware that they ever were adopted, but I don't know, except I do say this, that I did talk to Rich Still, the Human Resource Director and Risk Manager, and there are a number of governing provisions regarding the Code of Ethics. And Mike probably knows specifically, more specifically than I do, whether those are listed.
So Mike?
So in 12.60 under public disclosure, the second line says establish a code of ethics for officers and employees of the county. And then in 77, the ordinance was actually number, well, anyway, there was an ordinance.
There was an
ordinance. A code of ethics, and it's codified in the county code as 3.01 or 10. It's on a handout. If we get time tonight, it'll be there. It's 3.01.
3.05.
And it ties into a lot of chapter 42 RCW.
Okay. Yeah, thank you very much. See, some of us that have not had the pleasure of serving in some governmental capacity just don't have the background for something. And so I thought it was worth looking at, and so I appreciate that.
So, Ron, do you want to continue to be listed under 13, or do you want me to delete your name and then we'll have no committee for?
I think my name can be deleted.
All right, so there's now no longer any committee for Article 13. Okay. So, we made it through the whole list. Any concluding comments before we move on to the rest of our agenda? We've already done our discussion, and so we are in the public comment period. So before we call for that, are there any other comments?
I had an Article 14 listed.
Huh?
I had an Article 14 listed on the agenda.
Thank you. Okay, Mike, I'll get your question and we'll go to 14.
When we approved the agenda, I asked permission to have a one-page handout, and we talked about it being under subcommittee reports as a general item. So I've given Trish copies of the one page, if I could just talk about it.
Do you want to do that now, or do you want to do that under good of the order?
Well, when we talked about it, I thought it was under subcommittee, but I'll be glad to do it if we have time.
Okay.
To do it now.
So before we get to Mike, we'll go back up and do this proposed Article 14, and then can we get to you? Or do you want to do yours?
No, go ahead.
I'm trying to stick with my agenda, which I sometimes miss. Good thing Trish is over there reminding me. Okay.
I think, Norma, the proposed Article 14, it was misinterpreted. I think it's just a proposed idea for further discussion. I don't think it's been, if it's the Article 14 that I'm thinking about.
Which is what?
So what is Article 14?
It's the enforcement.
Oh.
So I think it just got misinterpreted. It's just something that they're working on.
All right, we've already discussed it.
Yeah.
Okay, and it was kind of confusing because it didn't have a name on it. Yeah, that's Article 14, so, okay. So Steve, I'm going to put you as the author.
Well, yeah, it's for our group, but you can, put my name.
Okay. So that's already basically been discussed. So Ron?
Well, I just want to clarify, it's regarding charter enforcement.
Yes.
I don't have it, that's why I'm curious.
It's the last 2 pages of giving them out.
Okay. My computer went down, I wonder if it get some of these.
I'll email it.
Okay, all right. So Mike, now you're on.
If people would right on the bottom or the top, submitted by Mike Gordy, 4/6/15. I appreciate it.
Oh, this is the paper.
The single
we just
sheet,
had that.
yes, and
Okay.
I consider it a draft. Generally, it's a concept I discussed in a January meeting, and it was to listen to the public, consider their concerns that were generally lumped as kind of open government, transparency, accountability, those sorts of things, and discuss those. And they may not be of the magnitude to go to the charter as an amendment, but they could be in what we approved as kind of a reference list of some things to go to the Board of Commissioners for them to please consider, because we heard some of these things from the public. So again, this is just kind of an outline. So for instance, under Open Public Meeting Act, the public access channel locally in Port Angeles, do we want to ask the board to televise formal meetings? The second one was an example. The Board of Commissioners don't produce formal minutes of work sessions. So sometimes over my term of office, the public had asked for that. And could there be a written record of public meetings? So if you go to listen to the tape, you kind of know the outline of what was occurring that day. Public records, I picked one that to me was kind of a personal interest. I don't think the public was ever informed, nor was the press, the exact process of the investigation report of DCD. So it's an example of a public records issue. It was quite major in the county, and if we could just better understand the process of how something of that magnitude is handled under the Public Records Act, because there were two, I think 3 formal press report requests for the public record. So I think it's important. In the document, public disclosure, it's Article 12, there is a reference to financial disclosure or public disclosure. So my concept there was that the prosecuting attorney could consult with the county auditor and say, for instance, what forms are available on the internet these days that are filed with the Public Disclosure Commission? And are there any left that are not available on the internet? You have to go to Olympia to look at them. I think, I could be wrong, but I think it's still the C forms. You have to go to Olympia. But nonetheless, whatever forms are filed with the auditor or the PDC, I think should be available to the public. So that was the concept there. Ethics code, as I mentioned, is 3.01, and then it ties to the statute for all state employees, elected officials, whatever. There's actually 2 of them. The major one, I think, is 42.
4252, if memory serves.
Right. And actually for criminal activity is what, chapter 4 criminal code?
I believe there may be provision in there, Title 9 and 9A.
9, okay, 9. So there are things that tie into that, but the point of interest we heard from a couple of public were conflict of interest enforcement, and it ties to one of the discussions earlier tonight. So that was an example of the Code of Ethics review, and then a settlement of claims against the county. How does that process work, and how are the Board of Commissioners, who have budget responsibility, informed about settlements that Clallam County has through the risk pool or other ways? So the concept was if we could just have the prosecutor, and generally it was agreed there could be research provided on these things. Now Mark gave us a briefing on the Public Records Act and public meeting. He gave us a briefing, so that may be covered, and he does have some handouts. The others might take a few pages, but for instance, I'd recommend we each get a copy. I think it's only 5 pages at the most of the county Code of Ethics. And then I had some other topics, but they were things that concern a relatively small number of people. So I just listed these, and I thought if we can get approval, it was unanimous in January that we wanted something like this to consider to draft. You each could look at these categories and think, do you have other examples within the categories or new categories we'd like to add to the draft? That way, Mark or whoever in his office could start to look at these and prepare a little packet if we could okay a draft.
Ron?
Yeah, no, Mike, just going back on the public access channel, you're talking about the Board of County Commissioners meetings being not our meetings here.
No, not here. But I know Port Angeles considered it. I think more cities probably do it than counties around the state. It's just, kind of a new age technique thing. And do we Some people say it makes elected officials get a makeup artist and.
Well, but then there is a code of ethics, because that was mentioned at one of the forums that I attended while I was on the campaign for this. I'm glad to see that there is a formal code of ethics that's been adopted. Did you want further questions on that?
Well, because it's late in the meeting, if you could just, the concept is this draft somewhere we want to go. Now, earlier I thought, so Mark had time for a memo, and in some cases, just print the code of ethics with a couple of examples. The other thing I was going to ask, if he has time, because he has a network with civil attorneys in the other counties and the Municipal Research Service, could we get a little bit of a pro and con on why counties do certain things with these open government type concepts? And then in his practice and in other counties, are there options they could bring back to us that we could do in Clallam County to better kind of open up government to local citizens? Now, some specifics of public meeting law, records requests, those are specifics, but they may have some others they don't other counties do.
Steve.
On the Public Records Act, and you gave the example of the investigation of the DCD, did the Public Record Act not fulfill bringing that forward? I'm just trying to, did someone ask for it, they didn't get it?
Well, there were, as I understand it, and I've never heard anybody address this, that's partially why it's my example in this case, is that 2 newspapers asked for the report, and it took months and months and months. And there were periods when there was redactions going on, some exchanges between attorneys for the DCD director and attorneys for Clallam County, probably attorneys for the RISPO. So I'd like that kind of just documented, what happened and why, because many months went by, so the public was really not informed. If we represent the public, I think we should understand the process of what happened there.
So they never got it?
I don't know. Eventually it was public and it was put on the county's website, and if they went to that site, they could print it. You know, it's sizable, it's an $80,000 report, plus a lot of staff time from the county. But I think the process should interest us. How do major items like that get handled? And then what happens as far as the county's response? Because there were, I think, some serious charges in the report. Felonies, gross misdemeanors, number of things.
Well, I think that's a different issue than the Public Records Act. I mean, I think those are 2 different
That's why I said
things.
the process. How was that handled?
From the public records or
Steve,
from?
I'm going to call
Okay.
in Susie Detterman.
I've just got a question. Is it your intent to incorporate this in some way into the charter?
That's up to the group to decide. Is there something of magnitude you think is worth putting it on the ballot? Or is it something we just want to recommend to the county commissioners? They consider taking some steps to add a little open government, transparency, accountability, whatever we're going to call it, in Clallam County government.
This, Mike, is like your first report, just like the first committee report, so you're looking for input from folks on adding to this list.
And generally the bold topics or some examples that they know of or that they've heard from the public during the public comment period. But I kind of was hoping if we could look at this as a draft, public would look at it, but it would give Mark an idea of where they might go with some research.
Ken?
Yeah, kind of just wanted to ask Mike a question on this Public Records Act and the example you gave. I guess I felt like part of what I was hearing is, let me see if I can phrase this as a question. Are you telling us that there isn't a clear, clearly defined process for that type of investigation and how it would be handled, how the information would be processed? And
I think that's a pretty good summary. I mean, my experience as a commissioner was that we didn't formally as a board look at that report as the managers of the county. And there is a document, multiple days, the county administrator prepared a kind of summary of how we get to accountability by the Board of Commissioners. Look at the report and maybe consider some action because of the actions of the person subject to the report. And to this day, there was never any, I asked for it several times, but I couldn't get a second vote to discuss that report. And we paid $80,000 plus, and there were some very serious charges. And so I could never get a second vote. I just think that report is really owned by the public. The infractions, if they're true, and they were allegations done by a former FBI agent that documented it all, to me fairly serious, but again, they were allegations. And so, should the board have done something about it? I think we owe that to the public.
It raises an interesting question with respect to an elected DCD director, where that person is responsible for, making final determinations on land use rights, both as favors and, it seems like an interesting, I think what Mike's getting at, it makes a lot of sense that maybe that should be part of the discussion. I'm not sure how we get there from here.
I'm going to call in Connie, and then we'll probably have to just continue this discussion at our next meeting, because we need to get to the public comment period, and then and also we handed out the real minutes of March 16th, so if we have a chance to review those, maybe we can actually get them voted on in our packets before the end of that meeting. So, Connie.
Well, the subcommittees have already met initially, and I know I, for one, because we couldn't as a group sit down and go through a chart and say, okay, we have this comment, and I think it should go under this article or that article. Some of what you have brought up could be dropped, because there may not be anybody who sees that it could fit in a particular article. So whether or not it goes in an article, or it's for us to be considered as a group to suggest a resolution to the commissioners, I think that's where this needs to go. I don't know that we all individually need to try to figure this out and where it would fit and what we should do with it. I think maybe there should be, if you want these things considered, maybe figure out which article they should go in so that it can go to that particular subcommittee to be discussed.
So generally, 8 and 12 are the articles that they would fit under. Ethics, public disclosure of what's the phrase, officers and employees. And everybody takes an oath and we're subject to statute. So if you read chapter 42 of the RCW, clearly there's an effect on elected officials and public servants generally. Actually, two separate statutes, but it covers both groups.
So, seeing no further hands, we will move on in the agenda to the public comment. Is anyone? I think the sign-in sheet is back on the podium, isn't it? Okay, so please sign in.
Good evening. Thank you for all the hard work you're doing tonight. As you might guess, I attend a lot of these meetings, and I think this one has been the most entertaining and informative of any I've attended last year. Several things come up. There's one thing I wanted to comment on tonight, but as a result of what came up tonight, I'd like to make 3 comments and 1 request, and I'll be as quick as I can. First of all, on the grand jury, you were asking about further information on the grand jury, and I didn't come prepared for this, but I just want to make a couple of comments about it. One of the first enabling acts of the statutes is that the common law will be recognized in all courts in Washington unless it conflicts with statutes. And I think that's going to be the critical part to consider, is what trumps, the statutes or the common law. Many of you may know that the grand jury concept was not in the main body of the Constitution. It wasn't until the Bill of Rights came up. It was in the 5th Amendment to the Bill of Rights where the grand jury was first brought up. So it was never intended to be a part of the judiciary, never intended to be a part of the prosecutor, but citizens who want to keep an eye on their government, citizens who want to question the actions of their government for its legality, should be able to convene as a grand jury and be able to ask these questions without having to get the permission of the judiciary. And as the statute recalls now, you have to have 2/3 of the superior courts in a given jurisdiction before they will call a grand jury. Well, suppose it's one of those judges that needs to be examined. You're not likely going to get a grand jury to sit in consideration of charges against the judge. So this is something that really needs to be considered. It is the only way to really get complete control of your government is with a functioning community or common law grand jury. Second thing, this sheriff in his testimony earlier, a couple of weeks ago, I guess a couple of months ago, about a month ago, suggested that the sheriff should be a post-certified law enforcement officer before being eligible to run for sheriff. Well, I think that the office of sheriff throughout history, the most recent history is different, but throughout history there has been a civilian in charge of the sheriff's department. They were the bailiffs at the court, they served the papers for the court, and they did run the jail to make sure that people were going to be around for court if they were involved. So a sheriff can easily get certified after being elected, but we don't need to put any more requirements to make it difficult for a civilian to be elected sheriff. The sheriff, as you know, is the highest law enforcement officer in the county, and it should not be just a law enforcement officer that's eligible. I'm sure all of you have heard of the concept of the thin blue line, where it's very difficult to get police officers to go against other police officers because of this fraternity that is perhaps in effect. So I would like to see everyone be able to run for sheriff because that is the voters' will. Salary Commission, many of you realize, or maybe remember this, only been a couple of months ago when one of our county commissioners made a not too veiled threat in the press to lower the salaries of most of the female elected office holders at the time. And I want you to be very careful about sending those types of responsibilities back to the commission without some real teeth in it, because you don't want it to be such that it is at the Port of Port Angeles now, where they have artificially low salaries so that the only people that can possibly serve as a port commissioner is somebody that already has an independent income or independent wealth. I think they pay, what, $12,000, $14,000 a year? And certainly you can't make a living if you're still in your productive years. You can't run for the port commission and expect to make a living at it. If you're going to run for a county commission, you want to be full-time and be able to spend as much time as you can on it and not have to be out looking for a part-time work. So I would certainly be anxious to see you have a salary commission with some teeth that's somewhat independent from the county commissioners. Finally, Mike, you brought up something about the county, or the community access channel, and we have one. We have one that has been in effect for 12 years, except the city won't let anybody put anything on it. I'd like to ask this body to send just a polite request over to the city saying make that public request or public access channel available to the public. Stephanie has recorded every one of these, and we have them on our website, and they should be projected into people's homes. There's a lot of people that can't come down here and visit these meetings.
Okay, and you can wind up because you're...
I'm winding up right now.
Okay.
So I would really urge you to send a polite request over to Dan McKean at the city and say make the public access channel accessible. Thank you.
Would you state your name and address for the record, please?
My name is Dale Wilson, Post Office Box 817, Port Angeles, 98362. Thank you.
He is signed in at the podium, Trish, so we'll have a written record. Okay, any other public comment?
Yes.
Please sign in at the podium there.
Okay.
Just a question of clarification, Madam Chairman. Earlier this evening, Mr. Miller said that he campaigned on a open agenda, I believe is what he said. And I'd like to know what that is.
I think he stated that he wanted to live with your position.
Well, my campaign position was to make the prosecuting attorney position nonpartisan.
That's it?
That's it.
Thank you.
Madam Chairman, the name and addresses for purposes of the
Oh.
recording.
Okay, okay.
Ford
So- So Bob, did you give your name?
I did.
Okay, thank you. So for the record, then, if all public comment will please tell us, even though you're signing in, tell us with your name and address for the recording.
Echo and P.O. Box 111, Clallam Bay, 3 areas. I call it the C words was brought up tonight in dealing with coordination. I want to emphasize why the term coordination, if you're going to do this, needs to be in the document. It can't be insinuated. This part of the country has a long history of our federal government, if not also our state government, using C words and not adhering to them. For example, a lot of land transfers to the federal government in Clallam County were done through what's called a governor's deed. And within those governor's deeds, they use the C word called consulting. And the particular federal agency takes that to mean, well, we'll notify the state. Doesn't mean they're going to consult with them. It means the feds take that to mean that they're going to notify the state that they're doing something in those lands, not consult with them. So that's the value in actually using the legitimate word and standing behind it and having the teeth behind using the word coordination. Because if you're just insinuating in your documents that you're going to coordinate with the state and the feds have a long track history of redefining what that C word means in their terms. And I would beg of you. Lastly, on this Ethics and Oversight Commission thing I presented at the beginning, kind of heard some conversation tonight about code of ethics being in the county's ordinance already. But I pose the question to you then as you address this, what's the enforcement action within that code of ethics? And I would suggest you take a look at that. And I think that helps get, maybe we have the core ethics there already in the ordinance, but who's going to enforce that? And will it be a citizens commission? Will it be a function somewhere within the county government itself? So I would ask you to take a look at who's going to enforce that code. And I don't think you're allowed to ask me a question, but I'm more willing to answer it if you're allowed.
So, Lola, you have questions?
I just was looking at this ethics and it said enforcement and penalties section was deleted. I don't know why, but repealed by ordinance 796 in 2006.
Might have moved to another section. We're pulling that ordinance.
Any other public comments? Hearing none, we'll close the public comment and move to the good of the order. Ron?
Yeah.
Ron?
I think it's Ron, go ahead.
No, go, you're down there first.
Okay, well, actually, on Friday, our Swim Sunrise Rotary Club invited Norma Turner to be the program. She graciously asked me to assist because I'm a longtime member of that Rotary Club, and we tried to inform the pretty good crowd that what the Charter Review Commission was all about, and I think the report was very well received. And I handed out to each of you a trifold that Norma had put together. And so if you want some quick talking points about the Charter Review Commission, it's contained right there. And I think it was very useful. There is one thing, we only have 7 home rule charter counties rather than 8. I should have picked that up. I was, the reader, but it's still very helpful. Thank you.
Connie, do you have anything to say? Go to the order comment?
I just want to know, I have a list of the meetings for tomorrow. I don't think I have a list in all of my paperwork. I don't know if there's a printed list or
You should have got an email at home.
It's on email, Bill.
I guess I have to go home then.
It's on email.
I haven't been home.
Steve, do you have anything for good there? Ron?
Well, I'd like to invite folks out to Forks on the 18th of April at 1 o'clock. I can tell you how many minutes, hours, and days that is. That's when the city will be dedicating its brand new Rainforest Arts Center. And so we would love to have visitors from afar. I know Mayor Kidd, for example, is coming and others. So it's 18th of April. It's a Saturday at 1 o'clock. And it's part of Rainfest, so there's actually things going on that whole weekend. And you can check the Forks Chamber of Commerce site for that schedule event. the following week. There's also things associated with the coastal cleanup and a trash fashion show, and some other things that are, and a Rivers and Oceans Film Festival.
Glenn?
Can I make a motion?
We're just doing good of the order right now, and then we can come back to a motion. Do you have any comments for good of the order?
No.
Ken? Mike? Do you have any comment for good of the order? Maggie? Noah?
Just a comment that tomorrow night's evening meetings, I normally would be participating in 4 of those 5. It moved from Wednesday to Tuesday, and I cannot attend. I just didn't want that to be misunderstood as lack of interest. I had conflicts I cannot get out of. And I appreciate the fact they were moved for Rod, because he has a whole lot more difficult schedule than I do.
Sue? Ted? Okay, my 2 comments for good of the order is that we had some earlier discussion about trying to create some sort of questionnaire for our public hearings. And I don't think it's too early for us to start thinking about what that would look like. And what we found historically is, you know yourself, when you go and there's a public hearing, you may have 20 people in the audience and only 10 want to get up and speak. Well, the other 10 probably have some good input for you. They just don't like to get up and be in front of the mic. So I think it helps us to get more input if we can create a written document. So I'll put that on the agenda for next meeting, again, to create what that document's going to look like. And then the last thing is, I would, as a courtesy, appreciate if everyone would just send me notification of when any subcommittee is going to meet, and I can just keep track of what's going on in the universe that way, okay?
Were we going to try to do meetings or minutes or not?
Oh, yes, thank you. Good thing you're there, Trish. I might just not get things done. So Trish did hand out to us, it was on your chair at break, the real minutes from March 16th. Hope you've had a chance to review them, and we would like, if you're willing, to go ahead and adopt these minutes so that we don't have a hot 40 of minutes to look at each time. So is anybody, Maggie, are you ready to look at these minutes?
I looked at them.
All right, is anybody willing to move for their adoption?
I so moved.
All right, Maggie moved to adopt the minutes of March 16th, and Ted seconded. Is there any discussion, corrections, concerns? Other than Steve yawning, we're going to call for motion then. Those in favor of the minutes of March 16th?
Aye.
Okay, now, Glenn, do you want to make some kind of motion?
I just want to help the winnowing process and just say, and make a motion that the subcommittee chair forwards a priority list of the issues on their, that they discuss, and the priority of what is most important and what is least important.
So Glenn has moved that subcommittee reports be written in a way that there is a prioritization on issues. Is there a second to Glenn's motion?
I'll second.
Ken seconded, okay? Moved by Glenn, seconded by Ken. Is there any discussion? We have actually 2 minutes before we have to adjourn.
I'm opposed to the motion for this simple reason. I think each subcommittee should decide for themselves. In general, it's a very good idea to prioritize, but there can be times in a subcommittee or committee's deliberations where they're still working on what the issue should be, and there's not a consensus as to what the priority should be, and it could just lead to interminable meetings. I think it should be optional to the committee whether or not they prioritize issues.
I think it would be a good idea, and if possible, that people could do it, that probably would help the discussion. Call for the motion. Those in favor, raise your hand. 1, 2, 3, 4, let's see, 1, 2, 3, 4, 5, 6. Is that it? Okay, and those opposed? 1, 2, 3, 4. So the motion passes. And somebody abstained. Who abstained? Maggie abstained. Okay. Thank you very much. Hearing nothing else, we will adjourn our next meeting.